Good morning, everyone, and welcome to Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you, everybody, so much for being here. I got to tell you, this is quickly becoming my favorite day of the week. It's quickly becoming my favorite show that we do. I really look forward to it, and I think today is going to be a really fabulous episode of Sunday Funday. So thank you, everybody, for being here. I already see a lot of familiar faces, Afton and Melissa Loves True Crime and Alicia K. Mayo and Genzo33. Thank you, K9, Catherine. Thank you, everybody, for being here. See me sharp. Just quickly, I know that we have some new people. Some names I think are new to the chat that I'm as I watch everyone check in. Just to introduce myself, my name is Joshua Ritter. I am a former LA County prosecutor. I was a prosecutor in the LA County District Attorney's Office for 10 years. I left. I went into private practice. I've been a criminal defense attorney for nearly as long. The whole reason we started this channel and the motive and purpose behind it and mission is to give you a perspective from both sides of the courtroom, and so that we hope that we do that. We got one rule on Sunday Funday, and that is no lurking. So please check in. Just say hi. Tell us where you're from. Would love to hear from everybody this morning. And please make sure we got to pay our dues to the algorithm gods. Please like this already. Please subscribe if you haven't. We're getting so close to a brand new breakthrough on numbers, so I would love for that to happen live this morning. We are just a few numbers away from hitting 26,000 subscribers, so wouldn't that be fantastic if it happened this morning? All right, what we're going to do is we're going to jump in to voice messages that you guys have left over the past couple of weeks. They're fantastic questions. As always, you guys showed up. You brought the heat. I think you're really going to enjoy it. I've listened to them all and done my research, so we're ready to go. But make sure you stay to the very end, because we have a giveaway. We announced that we're going to be giving away a $50 gift certificate to Criminal Coffee Company. That is Derek Levasseur coffee company. He sat down for our conversation recently. Had a really great chat with him, and he said he wanted to somehow give back to our community. So we decided to put together this giveaway. We had a lot of people enter, and we do have a winner that we will announce at the end of this Sunday Funday. But let's jump into it, all right? Let's stop talking about it and just go ahead and do it. And I got to say, I say this every single week, but you guys absolutely showed up. You came through. Thank you again. These are great messages. Let's jump into the first one, and I'm going to pray. Kaylin, tell me, let's get the technical quirks out of the way early if we have to have them at all. All right, let's get this going.
Hello, Joshua. My name is Lisa Marie. I really appreciate your podcast recordings and the staff you have. I enjoy listening to your podcast and other trial commentators, not so much to hear about the crimes, but actually to keep my mind engaged as I'm getting older and hopefully to stay away from Alzheimer's. Anyways, but my question today is, are hearings included in the appeals process? I don't know much about appeals process, but how do the judges get their information? Do they also include the hearings along with the court trial transcripts? Thank you so much for your time. Bye-bye.
Lisa, thank you so much for kicking us off. And I'm glad that what we do here can keep your mind engaged. I didn't think about that as being a pleasant side effect of all of this, but thank you for asking a question and contributing. And the answer to the question is, well, first of all, the question was, are hearings, meaning like evidentiary hearings, hearings that take place before the trial begins, maybe hearings that are taking place in mid-trial, are those included in the appeals process? And the answer is absolutely yes, if they have to do with what the subject of the appeal is. So one of the big parts of bringing an appeal, and I'm not an appellate attorney, but I have worked on some appeals. I have worked with attorneys on appeals. But one of the big steps in bringing an appeal is what they call setting the record. In other words, first thing you do is you order all the transcripts of everything, and then the attorneys go through and they decide what of that record is going to be important to the Court of Appeal, because that's all the Court of Appeal is going to get. In other words, they're not going to get evidence that was not introduced at trial. They're not going to get, articles that may have been written, things that took place outside of court, discussions that attorneys had with jurors after the fact. It's only things that are on the record, meaning being transcribed or narrated, however that jurisdiction handles it, in court. And then they go back and they say, well, listen, this evidentiary hearing that we had 2 weeks before trial started had to do with this expert issue that we're bringing our appeal on. So we want that hearing as part of the record. Once they've got all those transcripts together, both sides kind of have to agree on the accuracy of all of that. Usually that's not in contention. And then that's sent off to the Court of Appeal along with your appellate paperwork so that the Court of Appeal can refer to that, because that's their entire universe, is dealing with the four corners of the appeal papers that refer to nearly on a line item basis to some part of the record so that they have a way to make the ruling. And that's why you see a lot of times you hear attorneys make objections. You hear attorneys talk about, for the record, just making sure that if this becomes an appellate issue, they want that part of the record that they objected, that this was an issue. Because if it's not part of the record and it's just something that attorneys were bothered by but didn't bring up in court, it can't be part of the appeal. So excellent question, Lisa. Thank you so much for asking. All right, let's move along here.
Hi, Josh and Tiffany. This is Maureen. I think I may still be the only Maureen that calls. It's Sunday evening, March 16th, and I didn't get to listen to all of Sunday Funday Live today. So, Tiffany, you had asked me a question that I didn't answer because I wasn't here, and I wanted to answer. You asked if it was my birthday because people were wishing me happy birthday. Tomorrow, St. Patrick's Day, is my birthday, which is why my parents named me Maureen. My last name is actually very Irish. It's Donahue. And so they said, well, hey, we got to give her an Irish first name. But anyway, and this is not for you to play, but I was thinking one thing you might want to do just at some point is define for international listeners what a Hail Mary means when you say, that was a real Hail Mary maneuver or something, because international listeners are not going to have a clue what that means because they don't have American football. So that was my only comment. I really do love Sunday Funday. I think whichever one of the two you came up with it's brilliant. I think people really love it. And thanks a lot.
Maureen, first of all, happy belated birthday, born on St. Patrick's Day. How lucky are you? And you said as I was listening to it again, you said you don't have to play this. Well, I wanted to play it because you bring up a great point that sometimes I use a lot of phrases or turns of language here that may not be entirely appreciated by our international audience because they do not have American football over the world. And for that, I feel sorry for them. And I hope that American football spreads all over the world. But what is a Hail Mary? And I thought I could just explain it, or I could try to look it up because I don't know where it started. And so we looked into it. So it goes back to the 1975 NFC divisional playoff, which was a very important game. It was between the Dallas Cowboys and the Minnesota Vikings. And late in the game, with just seconds remaining, the Cowboys trailed the Vikings 14-10. It was fourth down for our international listeners. That means they did not have any more chances. This was their last chance. they had 16 yards to go, meaning if they did not get an additional 16 yards, they would lose the game. And they were on their own 50. So this was about as desperate a moment as it could possibly get in American football. And with seconds left, Roger Staubach, who was a hero amongst Cowboy fans, threw a pass nearly 50 yards. It was caught. They scored a touchdown with seconds just remaining, and they won the game. And afterwards, famously, now very famously, they interviewed Roger Staubach and asked him, what was he thinking? What was he doing? What was the plan on that miraculous last second long pass play? And he said, quote, "I closed my eyes and said a Hail Mary." And that's how it all began. So he was a very faithful Catholic, and he decided to say a little prayer, but that phrase, Hail Mary, became attached to the idea of just one last ditch long pass effort to try to win a game. And that's the reason I use it, is that you'll see this oftentimes even in the trial world, in the criminal trial world, where people make one last ditch desperate effort, and it's on a wing and a prayer that they could possibly pull something off. So that's where that comes from. So Maureen, even though I don't know if that was entirely your purpose in asking that question, you asked a wonderful question, and it got me to do a little bit of research. And now all of you are more well equipped for next time you're at your trivia night at your local bar or pub to be able to answer a question as to where the phrase Hail Mary comes from. So thank you for that, Maureen. All right, let's move along here. Lots of questions this week. I'm going to try to get to as many of them as I possibly can, guys. Why won't it let me do this? All right, tell me if this works, Kaylin.
Hey, Josh. Love how you analyze things, legal things, and teach us about the law. I was wondering about jury instructions, how those are derived. We've seen those argued in some cases. Does that vary from jurisdiction to jurisdiction? And can Karen Reed's team submit guidelines to clarify how the jury should proceed? And I also wondered, you mentioned about getting a badge as a prosecutor. We heard how Alec Murdoch misused that. How does a prosecutor properly use their badge? Thank you very much.
Suzanne, those are excellent questions. Again, what I love about this is these are questions I never would have thought to even answer myself until you guys asked them. So first of all, having a badge as a prosecutor, I got to tell you, is as nerdy as it sounds, was a very cool thing. It was something that I carried around with pride. Most prosecutors do carry it with them on a daily basis. It serves no official capacity that I know of, because along with your badge, you also get a DA ID, and you use your ID to get in anywhere. But everybody carries their badge on them. I think because we all secretly think it's very cool. I actually had a wallet where my badge was part of the wallet, so I could carry my money and credit cards, and it was also my badge, which was also a clever way for if I ever got pulled over and they asked for my ID, it was, oh, yeah, sure, let me go ahead and grab that out of my wallet here. Oops, did you accidentally see my badge, officer? The point, though, was we got in big trouble if we ever tried to use our badge inappropriately. In other words, to try to get out of a traffic ticket. If they happen to see it on an accident, I don't think that was a problem, but try to get out of an accident, try to gain entrance to, a nightclub, pass everybody in the line, whatever. You weren't supposed to, quote unquote, badge people. But it was, just a you used it in your swearing in ceremony. It was something that you had with pride. I had to give it back when I left the office, which I was very sad about. But I will tell you one story that is also incredibly embarrassing. And I just thought of this as we were talking about badges, but when I was a young DA, I was filling up my car with gas and in a hurry on my way to work. And I get to work and I'm looking for my wallet and I don't realize where it is. And my wallet, like I said, happened to have my badge in it. And apparently I had put my wallet on top of my car when I was filling up. And as I drove off, it fell on the ground. And I went back to the gas station and it was nowhere to be found. Well, guess what you have to do when you lose your badge as a DA? Not only do you have to have some very embarrassing conversations with your supervisors, you actually have to walk into a local police station and report it missing, because they have to put out a crime report for if that badge is ever recovered, that they have my badge number so that they know that it can be returned. End of the story is it's never been returned. I don't think it's ever been recovered. There is some kid going around in East LA with a badge still in his, in a shoebox under his bed, thinking it's very cool. And if you find my badge, give it back to me because I would love to have it. So that's about badges. But her big question was about jury instructions. And what I love about this is I think jury instructions are probably the most overlooked, yet the most important thing about a criminal case. Everything starts and begins and ends with the jury instructions. The first thing that you do when you get a case as a prosecutor or even as a defense attorney is you look up the jury instructions, because that's the whole case. What do you have to prove? So we would go, I get a case, it's a fraud case, it's a 211, it's a homicide, whatever it is, I'm going to need to look up what those jury instructions to make sure that I can satisfy every single element of that. So who puts together those jury instructions? Who comes up with them? Are they different from jurisdiction to jurisdiction? Yes, they are. The laws are different in every state, and the jury instructions are slightly different in every state, though they all are similar enough. But again, you caused me to do a little research here. So here are the did I forget how to do this? Let me see if I'm doing this right. Okay. So here are the CalCrim. This is from last year. These are the Judicial Council of California Criminal Jury Instructions. We refer to them as CalCrim. So everything is what CalCrim number is that? What CalCrim jury instruction is that? And if you go through the little preface here, and I'm not going to take a whole bunch of time on this, but I thought this was very interesting. First of all, they have a advisory committee on the criminal jury instructions made up by a bunch of different judges and attorneys. This name right here may be familiar to some of you, Honorable Lisa Lynch. She's a judge in Los Angeles who I appeared in front of many, many times. She's a very, very good judge. She also is the judge that presided over the Harvey Weinstein case. So these are working judges, and they sit down on this committee and they try to come up with what would be the best instructions to have on these things. One more name I wanted to show you on this, and then we'll go to what they explain. This is the task force members. I don't know. There's so many committees and members and everything that goes together to putting these instructions together. But this gentleman right down here, his name is Pat Dixon. Pat Dixon was the head of major crimes when I was a law clerk in the office. He's a very great guy, and he's an avid sailor, and I sailed with him a few times. But he's also heavily involved in these committees and everything else. But if you go to the preface, which I've never read before, so thank you so much, Suzanne, for causing me to do that. The opening line to this thing says, these instructions request the work of the task. These instructions, represent the work of the task force on jury instructions, appointed by Chief Justice Ronald M. George in 1997. Our charge was to write instructions that are both legally accurate and understandable to the average juror. That loaded sentence there, remains to be seen, because jury instructions are notoriously difficult to understand. And they talk about this entire process that went into trying to put jury instructions into everyday language. The problem is the law doesn't operate in everyday language, and it's hard to construct things that are both legally accurate and also easy to understand. And then they go on to say that these instructions were prepared by a statewide committee of justices from the Court of Appeal, trial court judges, attorneys, academics, and lay people. And that was the purpose behind all of these things. So what you do is, you're looking for, you have a case that's murder. You go through past all of the introductory pages and thanks to everyone, and you look, okay, the 500 series happens to deal with homicide. And you turn to the 500 series and you look up first degree, second degree, whatever it is. And then you get here, I'll just show you what some of these instructions look like before they're presented to the jury, by the way. Pass. I mean, you can see there's just thousands of jury instructions on hopefully everything. And they have to do with evidence, pre-instructions, post-instructions, duties of the jurors and everybody else. Here, let me get past all of this. Let's find a good one. These are like all the introductory questions. Reasonable doubt. I mean, everything that you hear these judges reading to them, but I'm trying to find one that has to do with, here. Okay. So causation might be a very common jury instruction. And you can see, though, how it's written. It requires you to actually do quite a bit of editing. An act or omission causes injury, or insert other description if the injury or other description is the direct, natural, and probable causes of the act or omission. And the injury, and every single one of these instructions, you have to painstakingly go through the instructions and fill them out properly, so that when you read them to the jurors, when they're sitting in court and their eyes are glazed over and they're halfway asleep, and we're doing the most important part of the trial, which is reading them the instructions are accurate. And then they get a copy of these instructions when they go back into the deliberation room. So hopefully they're looking these things up, because these are literally the entire playbook of how they should decide the case. And what every single question that you hear jurors ask, it's probably because they didn't sit down to actually look it up in the instructions. And that's what judges usually do, is go back to the instructions to tell them the answer to their question. But the last thing that Suzanne asked was, can you come up with your own instructions? And the answer is yes. We will oftentimes do what's called a pinpoint instruction, because these instructions don't cover everything. So sometimes you have a particular issue, or maybe it's a particular crime that was charged, and you have to literally sit down and construct it yourself, or ask for the judge to give what's called a pinpoint instruction yourself on what you want said to the jurors, because they are that important, because they also become part of the record on appeal. Afton says, what usually happens is there's a conflict between written and verbal. What usually happens if there's a conflict between written and verbal instructions? The verbal instructions are the judge reading these written instructions. So the instructions are coming straight from this. The judge just literally sits down with a stack of these instructions and goes through all of them and reads them to the jurors. Anyhow, that is your little Josh Professor moment of the day. But great question, Suzanne, and thank you so much for asking. And now let's see if I can get back to actually sharing this thing for everybody again. All right.
Hello, Joshua and Tiff and Kaylin. I have been thinking about calling in and doing a little recording for a while, but I haven't, because my girl Alicia K. Mayo has been representing Tennessee pretty good. But I am Terry from Tennessee, and I've been recently catching up on all my true crime stories, and have heard the story of the young man who was held captive for 20 years up in, I can't remember where he's from, but it reminded me of the story of the 3 kids that have recently been found in Michigan. And my question is this: are there not going to be any repercussions for those family members, and in particular in this case, his stepsisters that knew he was in there and didn't say anything. Also, maybe you could touch on what could possibly be Miss Sullivan's defense for what she has done. How is the defense attorney going to handle this? I would lean towards a plea deal because there's an overwhelming evidence that this man has been awfully severely abused for many, many years. So this story is awful and sickening, and I cannot understand it. But the thing that bothers me the most is the silence of family members that know these people exist and at least have strong reason to suspect child abuse or
No, and then we lost her. Thank you so much, Terry from Tennessee. First of all, Alicia K. Mayo does represent, but don't let her steal your thunder. So if you've got questions, Terry, you feel free to ask them. You ask an excellent question. This is about the Kimberly Sullivan case out of Pontiac, Michigan. Very briefly, the facts of this case: her stepson, who is 32 years old now, was pulled out of school at the age of 11. No one had really seen him since then. He was kept in an 8 by 9 foot room. The last shower that he claims to have had was 1 or 2 years ago. He was given 2 cups of water a day, 2 sandwiches a day that was later reduced. By the time they found him, he was 5'9" and weighed 68 pounds, and he was near death. And the last time he left the property, he says he was about 14 or 15. So he lit a fire using hand sanitizer just to get people to respond to save him. Horrible, horrific story. Terry, though, asks, what about the family members? Are they in any kind of trouble? And the answer is maybe. They could be. Are they somehow accomplices or accessories in the fact that they didn't do anything about this? I think that's an excellent question. Terry also asks, what is her defense possibly going to be? I mean, that might be part of it, right? If she's claiming, hey, I never kept him captive, he could have came and gone if he wanted to. And in fact, family members visited and he never asked to leave. And family members saw him and they never thought anything was wrong. I don't know what kind of a twisted defense that she could possibly bring, but I do agree with you, Terry, that this will likely end up in some sort of plea deal because if people hear about the condition of this man, I was going to say young man, but he's now an actual man, I think they will be beyond shocked. A 68-pound man at 5'9" has got to look near the point of death. And I don't think she has a good enough excuse for any of that. So I think it likely will end up in a plea negotiation. But excellent question about a very twisted and horrific case. Let's go ahead and move on here.
Hi, Joshua. This is Rebecca from Sydney, Australia, down under. As I should probably say, the good old cliche greeting of "G'day, mate," which not many of us say here anyway. Recently have come across your channel and absolutely loving it. Quickly becoming a #1 fan after seeing you on Grizzly with Gisela. Quickly, a little bit about me. I am a social worker in a mental health prison in Sydney, Australia. Predominantly work with forensic patients and all other inmates that are suffering with mental health illnesses or needing diagnosis clarification for such things. Question is, in Australia, we have a lot go under the forensic system for murder. It is a common argument that people use mental health as a reason to get off their charges. It is not the case when you work in the system and you understand more the processes of what that is, what's involved in the ongoing treatment and plan for someone that is deemed a forensic patient. Often they are then monitored for the rest of their life and by the Mental Health Review Tribunal here.
Oh, she's got a part 2. Hold on.
Oh, part 2. Sorry, just very, very quickly. I didn't realize there was a time limit. My question quickly to you is, Is it the same case in America? Going by comments on YouTube, I can see that, you know, it is quite a common argument as well. However, more coming from the legal side of things, how did the prosecution look at it? And does prosecution feel a little bit defeated if someone has been granted by the courts mental illness reasons for their charges and yeah, that's the final decision. So yeah, just my question is, how does it feel amongst the legal side of things over there when you're going down mental health path?
Excellent question, Rebecca from Sydney, Australia. Thank you so much for calling in, and I love to hear from our international Courtroom Confidential crew members. You have a fascinating work that you do. The answer, I think, to your question is, are prosecutors frustrated by the fact that somebody might bring a mental defense, or that the judges might find that somebody is mentally incompetent to stand trial? And the answer is no, with an asterisk, and this is what I'll explain. First of all, there's a difference in American law as far as what is competency and what is insanity, and I think those easily get confused. Competency, first of all, is a standard that decides whether or not a person has the capacity to understand, one, their legal rights, their obligations, the proceedings that are taking place, be able to make informed decisions, be able to assist their attorney. So it's just, do you understand what's going on? Are you of the mental capacity to understand what's going on? And if you're not, pardon me, if you're declared incompetent, they pause the proceedings and you go back into treatment to a point where you might be able to regain competency. Perhaps that you need medication. Perhaps you just need to get past whatever sort of crisis and episode that you're dealing with. So people can go in and out of competency. Insanity pleas are something else entirely. Insanity pleas are a defense, and insanity pleas are a little frustrating for prosecutors to deal with, because it's not now saying, is the person presently unable to stand trial? It's saying, should they be excused to some extent for their conduct in the crime that they committed? In most of the United States, they follow you guys may have heard this referred to as the McNaughton rule. Very, very old law standard. Every jurisdiction, though, implements it differently, and some don't even allow for it. But it's basically that says, was a person from either mental health reasons or injury at the time of the crime, were they unable to, because of that, appreciate the nature and quality of the act? And did they know that it was either morally or criminally wrong? And that's a very different question, right? That question is, it's not even so much that you had some sort of mental illness. It's not even so much that you had an injury, but did it prevent you from understanding that what you were doing was right or wrong? If you are found that you are not guilty by reason of insanity, that, first of all, doesn't necessarily mean you're released. You then go into some sort of a treatment center, but it does mean that you're not necessarily found guilty of the crime, because we are saying, because of your mental capacity, because of your mental illness, because of your quote unquote insanity, you should not be held criminally responsible for it. So it's a very difficult defense to deal with. I will say it's a defense that is not brought as much as you would probably think, because you do have to have experts who can say that's what this person was suffering from. And it usually does require some sort of hearing and showing that this person suffered from something. In other words, you can't just come up with it after the fact and say, hey, I was insane, without some sort of history of mental illness, history of some sort of injury, something to point towards, because otherwise the judge is going to say, I'm not going to let you do this. I'm not going to let you bring this into the courtroom. But Rebecca, excellent question. I hope that answers your question. And it is a thing that I've had to deal with maybe once or twice in my entire career, and it's very, very difficult, and usually comes down to a battle of the experts, as it were. All right, let's move on to our next question here.
Hi, this is Krista from Oregon. I thought I'd just share my experience with jury duty as I was called for grand jury duty a few years ago here, and learned that, well, first of all, nothing disqualifies you, as one of the prosecutors was literally a weekly private Pilates client of mine. But one of the cases we had before us, it was kind of a, I guess, manslaughter, kid racing car, ran into this elderly couple just out for lunch and killed the wife and, severely injured the husband. But anyways, the defendant actually came in and I guess testified before us, which the prosecutor was like, okay, I've only seen this like once in my entire career. And it went about as you would expect, the stupidest thing he absolutely ever could have done. We knew the speed it was going from the car. There was witnesses to him saying let's race, and so we immediately caught him in lies. I don't know why he thought he would come in or why that was a good idea, but it was a spectacularly dumb thing to do.
Thank you so much, Krista from Oregon. First of all, I just got a little alert that we have a birthday shout out for Sue B. Sue. Happy birthday if you're still in the chat. Love to hear that. There it is. Happy birthday, Sue B. Sue. Oh, and Jen St. Peter, happy birthday as well. Fantastic. Thank you guys so much for being here on your birthday Sunday morning. Krista, excellent question. Not so much a question as sharing something, but it brings up an interesting issue about what are grand juries. And I thought maybe that's something that we're not all familiar with. There's two types of juries, right? There's a grand jury and there's a trial jury. And in fact, the trial jury was originally referred to as the petite jury. But a grand jury is called a grand jury because it's larger. A petite jury or trial jury is usually 12 or less people. A grand jury can be anywhere from 16 to 23 people. And there's something there. They have entirely different jobs and they serve under entirely different authority. A grand jury is entirely about a probable cause determination. They are trying to decide the question of, is there enough evidence to hold this person, bind this person over, indict this person for the crime? And that is not beyond a reasonable doubt. That is at a lower standard. It is at a probable cause standard. These hearings are always conducted in private. In fact, many times you may not even know that a grand jury has been convened. They are, for those purposes, they are sometimes used to test out whether or not there's enough evidence. Sometimes prosecutors will bring evidence to a grand jury, seeing if they can indict a person. And if they can't indict them, then they don't alert that person to the fact that they're even under investigation by the grand jury. They also sit for a term longer than just a case-by-case basis. In California, they sit for 1 year. If you go to be a part of a grand jury, you're sitting on that grand jury for 1 year. So what that means is you could be presented evidence on a case in March, and then they don't come back until July with more evidence. And then by September, they bring you more evidence and then ask you whether or not to indict a person. And it keeps all of that evidence under seal, and it keeps all of that evidence on the record and under oath. So it's also kind of an investigative tool. Very different from a trial jury. A trial jury only sits for that trial. They are considered the finders of fact. They render a verdict. It's about guilty or not guilty. So that's the difference between juries and grand juries. And I know some people who kind of have made it almost their part-time job to be a grand jury member, and they serve for a year and then try to serve for another year later on. And but her point that she brings up is that the defendant actually testified at a grand jury she was on. Very uncommon. first of all, very uncommon that the defendant would even know what's going on. Now, sometimes they do it letting the defendant know because they know, one, they can't keep the cat out of the bag, and two, they invite the defendant actually sometimes to submit evidence. Is there something you want us to present to the grand jury? Because that's the other part I didn't explain. At the grand jury, there is not the defense team present. It's not like a witness goes on and they present direct and then are cross-examined by the defense. It's only the prosecutor presenting the evidence. So they essentially have to wear two hats. And that is because that is oftentimes what is a point of contention is, did the prosecutor actually present a satisfactory amount of exculpatory evidence to the grand jury to give them a holistic picture of the question being asked of them? Or are they only getting one side and therefore they're going to indict, like the saying goes, they could indict a ham sandwich. So many times they'll invite the defense, hey, we're going to grand jury on your case. Is there anything you would like us to present? Are there any witnesses you would like us to present? I have not heard of a situation where they've invited the defendant, but I imagine if the defendant wanted to, I don't know why they would prevent him from doing that. And it's also probably to the defendant's own peril, as was pointed out by Krista, because it's sworn under oath testimony and is likely not going to help them unless they've got some tremendous defense. CJ says, do you have to keep mum for the whole time as a grand juror? Absolutely. You absolutely have to keep quiet about what you are, the cases that you're hearing, what you're sitting on. And I will tell you this too. There are some very high profile cases that have gone to grand jury that I cannot tell you about that have not been indicted. And that's because they don't know if they have enough evidence. Maybe they feel like they do. Maybe they're just trying to get people on the record for a case that they're trying to build. But it's one of the most important parts is that the grand jurors not let anybody know that they're sitting on that, because it could ruin the whole thing. Now, once a person is indicted, they unseal the grand jury transcripts. And then I imagine at that point, it's probably not as big a deal, but I don't think that they are allowed, still don't think they're allowed to give like an interview. But great question, CJ, following up on that. So you thought you weren't gonna learn anything this morning. Well, look at us. We're talking about jury instructions. We're talking about grand jury. Telling you, by the end of this, we're gonna sit down for the California State Bar and see how well we do. All right, let's move on to our next question here.
Hi, Josh. My question is about regarding insanity pleas and sentencing here in California. My brother was attacked in his sleep by his 30-year-old unmedicated schizophrenic stepson. He has medication, but hasn't been taking it for a number of years. My brother was stabbed in the head and hands multiple times. It's a miracle we still have him with us. His stepson is in the county jail, has been since November, and has finally been determined to be incompetent to stand trial. He has been sent to a state facility for treatment for 2 years or until deemed competent to stand trial. My question is, if he's never able to stand trial, what happens? Does he just remain in a locked mental health facility? Or if he does stand trial, could he plead insanity and be shown mercy and released? I'm understandably very concerned for my brother's safety and worried that we may not be as lucky next time and we could lose him. I look forward to hearing your answer. Thank you.
Wow. Linda, thank you so much for that. First of all, I hope that your brother is doing well and is recovering. That is a tremendous story and very, very scary. Yeah, and this kind of goes back to the conversation we were having a little bit earlier about the difference between competency and insanity. So what Linda highlights here is that, yes, if someone is found incompetent because they're suffering from some sort of mental crisis, they will go back into treatment and they're not released. They are in a lockup facility receiving treatment, and they will have periodic check-ins to see whether or not this person has regained competency. And that decision is made by doctors treating that person. If they regain competency, the clock starts back up on the criminal trial. In other words, the clock is on pause during that period of time for their due process purposes and quickly or speedy trial purposes. But if they're not declared competent, how long can somebody be held? Is it indefinite? The answer is no. there is a 2-year period in California, at least, where they can be held in this treatment to try to regain competency. What happens after the 2 years? Do they just get released out into civilization? No. If they are truly suffering from mental illness and need care and are not competent, and remember how low a standard that is. So you really have to be unhealthy to not reach that competency standard. They will apply, and by that I mean authorities, for what's called a civil commitment. In other words, it goes from the criminal world to the civil world, and they look to have them put into a treatment center permanently, because this is a person who's just not well and also dangerous. But then to your last point about what if he does regain competency and he goes to trial, will he be shown quote unquote mercy for his for pleading insanity? And again, it goes back to that question about what is sanity for legal purposes. And it's not about mercy. It's not about feeling bad. It's not about, oh, this poor person is sick. It's about, did they not appreciate the consequences of their actions? I worked on a case, just to give you an example, where a young man killed his father, and he said that a reason that he did that is that he felt his father was an evil spirit and that he was sent by God to protect the universe from his father being a messenger of the devil, whatever it was. Obviously, an unhinged person, obviously a person dealing with mental health issues. But her point was, yeah, but once he committed that murder, he ran and he hid from police, and he initially lied to police. That is a person who may have done something because they felt like it was part of the greater good for the universe, but they also knew it was criminally wrong. And therefore, that shouldn't satisfy the elements of an insanity plea. He knew, and this you see happen many times in these cases where they're pleading insanity. They're trying to hide. They're trying to cover it up. They throw away the murder weapon. They run from police because they may be untethered from reality in the way that they're acting, but they also know what they're doing is wrong. And they also know that it's either morally or criminally wrong what they're doing. And that is really the question that it comes down to in an insanity plea. Afton says, are there ever conditional releases for the criminally insane, such as mandatory medicine? Problem is you lose jurisdiction over someone. If they're not in lockup, you cannot force someone to continue to treat. So there's a long going debate about, we got rid of all of our state hospitals. And so our jails have now kind of become that place for people who are mentally unwell, and we don't know where else to put them. They continue to commit crimes, usually kind of petty crimes, and we continue to lock them up for as long as we can criminally, but then they're back to being released and they don't have treatment when they're on the outside. And that's a really sad thing because there's no place to hold a person unless you get something like a civil commitment. It's a much bigger conversation for another day, but it is a sad state of reality that there are many, many people who are just very, very sick, and we cannot continue to treat those people as criminals when they really need to be treated as unwell. But where do you put a person who's unwell, and how do you keep a person detained who's unwell? Because they have rights as well. If they haven't committed a crime, how can we take away their freedom? So again, big philosophical questions, probably not easily handled by my goofy butt on a Sunday. All right, let's move on to our next question here. Excellent question, though, Linda from California. Appreciate it.
Good morning. This is Annie from the Shenandoah Valley. And first of all, I just want to say happy spring. I am a victim of domestic violence, and I have 7 grown children, 4 of which are sons. And in regards to the Menendez, I can't say their names, you know who I mean. Fathers, provoke not your children to wrath. When children are being abused, they have 2 choices, typically suicide or to take out their fear on the abuser, which is to hurt them or kill them. And I saw it with my own eyes. Sons will actually turn on the mother because a mom is supposed to fix everything, put on the Band-Aids, get up in the middle of the night when the child is sick. And if any of you know Gabor Mate, he has been the biggest help to me to understand the psychology or psychoanalysis of what my sons were doing. They turned on me. A mother can't stop domestic violence. I mean, if she can escape, and I was blessed enough to get out after 30 years, but it's not easy and it's cost prohibitive. I'm not wealthy. He was the wealthy one. So I think we need to be very, very cautious and get informed individually about what domestic violence and in particular sexual abuse does to the psyche of a child. I have a daughter that is finally healing from the sexual abuse, and she's now 27. We are so quick to judge. Those men have been incarcerated for 30 years. Taxpayers are paying for their jail or prison, I mean. But are judges considering what it does?
Oh, and then Annie got cut off there. Annie, thank you so much from the Shenandoah Valley of West Virginia. Appreciate you calling in. I love that you were talking about spring arriving, and I could hear the birds chirping in the background of your call, just right on cue. But you bring up some really important and interesting points. First of all, you're absolutely right. Domestic violence is this vicious cycle that leaves a lot of people damaged, and it is something that is still, I think, not properly appreciated and not properly dealt with probably by the criminal justice system, and it's continuing to evolve and understand that. And we've certainly seen that over the last 30 years with the Menendez brothers case, and that's the case that you brought up, and talking about kind of how do we reflect on these men, how do we reflect on what they did, how should we treat this crime? And I think that's why this case is being discussed 30 years later. I don't think it's really all about, oh, it was a case that got a lot of media attention back in the day. I think the case is so important. It's something that still causes conversations because it brings up questions that are still relevant today, and it brings up issues that we're still battling with. And it's, it is not so cut and dry. Here's, I think, something that goes oftentimes misunderstood about the Menendez brothers case. The Menendez brothers case wasn't, and their defense never was, we were abused at the hands of our father, therefore we should be excused for our behavior. That never was their argument. Their argument was, we were abused at the hands of our father, and because of that, that put us into a mental state, a mental condition where we acted unreasonably. And they brought in their first trial a defense of what's called imperfect self-defense. So self-defense is what's called an absolute defense to a crime. Self-defense says, I acted reasonably in response to a threat to my life, and I responded with, I perceived that reasonably, and I responded reasonably, and I had to use deadly force. Therefore, I should be acquitted. I should be found not guilty of murder. Imperfect self-defense says, I had an honest belief that I was in fear for my life, but that belief was either unreasonable or my response to it was unreasonable. And that is the argument that they were making. And that is not a complete defense. That defense says that instead of finding me guilty of murder, you should find me guilty of manslaughter. They brought that defense in the first trial. The first trial hung. So some jurors believed that. Some jurors agreed with that. Others did not. But they were never hung on the idea of between acquittal, between not guilty and guilty. It was always between manslaughter and murder. They believed that they were guilty of something. And I think that's why it's a case that's difficult today too, because everything that you're saying, Annie, is absolutely true about the cycle of abuse, about how it rips families apart, how it causes psychological effects that really cannot be appreciated in the victim of that abuse. but they also shotgunned their parents to death. They also at one point went and reloaded the shotgun. I mean, it was a brutal murder, and there was no evidence that they were under any kind of threat to their life at the time that they did it. So they acted unreasonably, even though they may have honestly believed that their life was in danger. Again, I don't know if we're going to get into an answer on all of this, other than to say it was a case that I think continues to spark conversations. And Annie, you are part of that conversation, and I appreciate everything you're saying, and I appreciate you sharing with all of us your experience and what you've gone through. And I think it highlights a very, very important topic that we continue to need to discuss. So thank you very much for that. All right, let's move along here to our next question. And I hope I'm going to do this right.
Hi, Josh, Tiff, Kaylin, and everybody at Courtroom Confidential. This is Robin Hood in New Mexico. And my Sunday Funday question or topic is, I have a theory about Kohberger. I'm thinking it would not be ludicrous to think that this strange ranger, we all saw the picture of the selfie, that he could have devised and committed this horrible crime to create a topic for his PhD. He could manipulate it in many different ways. One, he's got the knife, which he could plant somewhere, maybe on someone. He knows what happened, allegedly, so he could make inferences and then study certain things about it, maybe even crack the case, right? But I think he's so strange that that could be the entire motive. What do you think?
I think, first of all, Robin Hood, it is so good to hear from you. I've appreciated your support for a long period of time. So thank you so much. The whole channel thanks you for calling in and leaving a message. Great question, Bryan Kohberger. So Robin Hood's question is, do we think Bryan Kohberger could have committed these murders? Well, she says she goes to the point where which I've never heard before, but she goes to the point of saying to create some sort of thesis for his PhD. Very interesting theory. I agree, Pilola's mom. Very interesting theory. I don't know if I went as far as Robin Hood, but I kind of feel the same way. Motive in this case is going to be a very interesting topic for how the prosecution is going to handle it. How, again, we've said this many times. Motive is not an element of the crime. You have to prove intent. You have to prove that they did it on purpose, but you don't have to prove the why. What was going through their head when they did it? Why did they do it? But I think it's a huge mistake in any case to not address it. And this case is no different. In fact, this case might be very important to address the why. Why did this man, if it's true, what the prosecution is saying, why did this man slaughter 4 college students? And I will say their names: Ethan Chapin, Kaylee Gonzalez, Zaina Kernodle, and Madison Mogan. Why did he take their lives? Did he have a connection to them? Was there a reason? Was he trying to make a statement? Did he have animosity towards one of them? Why? And I think that question is going to be ringing through jurors' minds throughout this entire trial. Now, I think the prosecution is going to present evidence that satisfies every element of the crime. I have no doubt that they'll do that. But if they don't answer the why, that's going to create problems. Robin Hood says, could it just be a pure academic pursuit? I'm kind of that same philosophy, that I think that this might be one of those things where this man thought, I wonder if I could get away with this. I don't know if it was some sort of sick, nightmarish experiment on his part. We know he studied criminology. That doesn't mean everybody who studies criminology is a secret sociopath, but Does this man feel like he was smarter than everyone else, picked a target at random, or had run into one of these people and thought, I bet you I could do this. I bet you I could get away with this. I bet you I could go in there, commit a murder, and never get caught. That might be as sick and twisted as what it all comes down to. I will say that recently the prosecution released a academic paper that he had written that they feel is eerily similar to the case that he had written years before that they want to introduce as evidence. I don't understand why they would want to be introducing that as evidence unless they're trying to say that somehow it played a motive in all of this. And if his motive has to do with some sort of academic paper he wrote, then Robin Hood might not be that far off for what they believe his motive could be. So I am, amongst many, many reasons, one of the reasons I'm looking forward to this trial is I want to know, what does the prosecution think is the motive for why he did what he did? Afton says, in my opinion, you have to be careful looking at schoolwork. It's not like convicting someone based on song lyrics. Right. Afton makes a good point. There's been many cases where they've tried to use song lyrics, academic papers. Listen, if that's all they've got is this academic paper, I think that could be a problem. But if they've got other things, and the academic paper kind of plays a role in all of that, it could be a very interesting theory, and we'll see how the defense responds to it, because they may try to laugh it out of the room like everybody else. And I see we have an alert, pardon me, that we just hit 26,000 subscribers. So you guys are all fantastic. Thank you. Thank you so much. I love when we hit these milestones while we're live. So appreciate you all. Thank you again. Let's keep it going. Let's keep that train rolling along. And thank you again, Robin Hood. It was great to hear from you. All right. Let's move on to our next one here.
Hey Josh, it's Farm Girl. This is probably a really dumb question, but something that I've always wondered. Is there a difference, or what is the difference between somebody being sentenced to life without parole and life without the possibility of parole? Thanks. Have a great day. Bye-bye.
First of all, Farm Girl, there are no stupid questions. I appreciate every single question that you guys send us. Farm Girl, also a very long time supporter of this channel. We appreciate you. What is the difference between life without parole and life without the possibility of parole? The answer is the language. It's exactly the same thing. Life without parole, or LWOP, is just the shortened version of life without the possibility of parole. It's just how verbose do you want to be in explaining the whole thing. But really what it comes down to is there's two types of sentences. There's what's called indeterminate sentences and determinate sentences. A determinate sentence is I got 9 years for a robbery. 9 years, meaning unless I get credit for good time, work time, unless for whatever reason I do something while in jail that or in prison that can earn me credits, I'm going to stay there for as long as 9 years. And at that 9 years, the state no longer has jurisdiction over me. And whether they hate me or love me, they got to let me go. An indeterminate sentence means they don't have to. So in other words, when you hear that somebody got sentenced to 25 to life, that means that the minimum the minimum that the state can hold you is the 25 years. They've got 25 years out of you. And it's only after that 25 years do you become eligible for parole. But if you're not granted parole, there's no cap. They don't have to let you go. And in fact, many times we hear about people who get denied parole again and again and again, and the state maintains jurisdiction over them because they have an indeterminate sentence of life, meaning they can hold on to them legally for their life unless they grant them parole. Again, in those indeterminate sentences, 25 to life, you might hear about somebody getting eligible for parole before the 25 years because they've been granted some sort of credit and time. but it's that 25 years, if they don't get any credit in time, they have to become eligible for parole at the end of 25. Now, that brings us to life without parole, or life without the possibility of parole. That means you're never even in the parole discussion. That is what the Menendez brothers are sentenced to. They're sentenced to LWOP, life without parole, meaning they don't ever have a parole board hearing. And that's what their whole case is becoming about, is their attorneys are trying to argue that without parole should be taken away. And they should just be given a sentence that allows for the possibility of parole, and then leave it up to the parole board. So great question, Farm Girl. Like I said, no bad questions. Kathy, thank you for the gift of memberships. And let's keep it rolling along. That was a great opportunity to clear up something I'm sure a lot of people have been wondering.
Hey, Courtroom Confidential. This is Holly in Houston. And rather than a question, this may take two. I don't know. We're going to find out, and I'm going to try to talk fast. This is a plea rather than a question. So it's regarding the Idaho 4 case and people's attitudes about it. These are concerns that I have carried since almost the start of this whole thing when it first happened. Yeah, I've been following that long. So, and I myself am hoping, I've been doing the very things that I'm hoping you guys will hear me out and agree needs to be done on either some or all. I just would really love for us to set the example and raise the bar. Okay. So the first thing is, we don't know all the evidence. People get lost in that. They're like, the only DNA is the sheath. There's no blood. It's all circumstantial. I've been actually just replying to people. We do not know all the evidence, and that's that. I'm not going to do keyboard wars with people, right? The second concern is that people are forgetting Bethany and Dylan and their families on both sides, okay? Bryan's as well as the Idaho 4 and Bethany and Dylan's families, they and their friends, they were affected and they always will be. They didn't ask for this. They didn't have any part in it. It makes me really sad. I actually have cried watching the things that people are saying. So, second one. Hey y'all, this is Holly. This is part 2. So continuing on, I left off with how Bethany and Dylan and the families are victims, and we need to be ever cognizant of that. The next one is no more speculating. Now, I know that we say that here, but not everybody does. Even on other channels where there are people, and it's not just trolls, they are so quick to go down that rabbit hole, right? Think back to where, and my point is this, before Hitler took charge of stopping the whole sealing frenzy that was going on, right? Many of the ideas that we had before have been proven wrong. Yes, agreed? And I know it is true for me. Our words matter. Our attitudes matter. We are online, and it's really easy to not be mindful of how they affect others. So I feel it's really important to try to stick to facts, okay? Have respectful opinions. Their opinions are always welcome, but they got to be respectful, always. Same with asking questions. No derogatory questions, no passive aggressive stuff, whatever. Falsely accusing, pulling things out of the air. Sometimes also, as a point, it's better to not say anything at all. That says a lot about character and integrity. So, yeah, and it's hard to not say anything. Amen. Sometimes for me it is. So let's be the example that we want to see in others. Let's raise that bar. And I really feel like we should rise above. Thanks, guys.
Holly from Houston, thank you so much. I applaud everything that you're saying, and I think that is why this community that we have here at Courtroom Confidential is so special, because I think everything that you're saying, Holly, we really, really do try to do here. And I'm not speaking just for myself. I'm talking for the community at large. I see you guys in the comments. I know how respectful you are. I know how inquisitive you all are. And I know how patient and objective you all try to be. And it's difficult. And I think Holly brings up a greater point about all of this, is that, we're all fascinated with this world of true crime, and we're all, we watch these cases and it's high drama and it's intriguing and it's interesting and we want to know how things turn out and we care about the victims and we care about, seeing that justice is done. And it can be difficult, myself included, sometimes to not let it become some sort of spectator sport, which it never should be, because we are dealing with real people's lives on both sides. As Holly points out, we are dealing with families who, when the final verdict comes in, guilty or not guilty, and we all kind of react and have our feelings about it, and oh, that was the right thing, or oh, that was the wrong thing, or oh, I'm shocked. Within a few weeks' time, we may move on to something else, but the families of those victims will never move on. Their lives are forever changed. Same for the families of the defendant. There's these beautiful kids that were robbed of this world, and their families have a hole in their hearts that will never be repaired. And the family of the defendant, the family of the Kohbergers, as awful as it may be to kind of wrap around in your head, they're never going to be the same. They're likely going to lose a son to prison for the rest of his life. Their name is now notorious for these murders. I always think about that too. These people got to there are Kohbergers walking the earth who got to go into grocery stores and use credit cards and everything else. And their name is now forever tied to this person that the police believe did an incredibly awful thing. So I agree with you on all of that. And that's why I make an effort, and I hope that it shows on this channel, to try to be as objective as we possibly can. But also I try to think about, when I'm talking about these cases, from the perspective of what will the jury think? And it's like, I don't want to be sitting here taking votes. Oh, that he's guilty. Oh, he's not guilty. Oh, the prosecution's awful. Oh, the defense attorneys are garbage, whatever it is. I mean, I fall into it, and we all fall into it, but I also try to think about, at the end of the day, this is a question for the jury. And what will the jury think about this? What will the jury think about the behaviors of the attorneys? What will the juries think about the evidence? Because they're really the ones who are the most important, and they're going to be making the decisions on all of this. So, Holly, I appreciate you leaving that message. I appreciate you bringing that point into our overall discussion, and for making our community better for it. So thank you, thank you, thank you. Let's move along here, shall we? Oop, let me just make sure I'm doing everything right. Hold on. I gotta refresh this.
With the new information that's been released regarding the Kohberger case, how strong do you think the prosecution is regarding the evidence? Do you think they have a strong case?
That's nearly the perfect question to come after the discussion we just had. So in that vein, let's talk about, what will the jury hear? You're asking me, how strong is it? My opinion on whether or not he's guilty really does not matter. And to Holly's point, we only know very little about this case. You asked me 6 months ago, my decision may have been very different than what it has been after all of this new recent evidence has come out. So we don't know everything. We have to wait for trial. It's absolutely true. There could be far more, or the evidence that we have heard could have problems. I mean, we hear stuff like they've got his Amazon records to show he purchased a knife, a K-bar knife, a sheath, and a sharpener. That, to me, sounds like really convincing evidence. Who knows, though, if they're able to actually bring the goods? I don't know if that under cross-examination is all going to fall apart. So, great question, Tiffany. And I love that we asked that question right after we had a discussion about kind of reserving judgment. But, that's what we're here for, is to talk about, how is this case playing out and how is it developing, and how strong do I think the prosecution is? Well, I think the answer to that first question, let me just adjust my seat here. Sorry. I think the answer to that first question is, one, it sounds like the prosecution has way more than we've been led to believe from the beginning. But Here is, I think, the question that will be presented to the jurors. You have a person, and assuming they can prove all of this, you have a person who made purchases for a K-bar knife, a sheath, and a sharpener. That same person, they believe, made purchases at a Dick's Sporting Goods for a mask similar to what's been described. That same person has a vehicle consistent with a suspect vehicle in that seen in that area on videotape. That same person, during the time of the murder, was either close in proximity to where the murders took place or had their phone turned off conveniently during the time of the murders. That same person has a description consistent with what an eyewitness saw. Now, eyewitness is never going to be able to ID him positively, but that person describes a general build, a general height, the bushy eyebrows, which I think we can all agree are not inconsistent, but are in fact consistent with Bryan Kohberger. And that same person cannot present an alibi that is rock solid. In other words, that same person was not 300 miles away. That same person was not having, in somebody else's home in their bed during that entire evening. You take all of that, and then you say, what are the chances that that person, with all of that circumstantial evidence, also happens to have their DNA on a knife sheath recovered from the crime scene? You're asking my opinion, but let's ask the opinion of the jurors. From the jurors' perspective, is that a fairly convincing case? And I think if all of this plays out, if all of this proves to be true, if all of this stands up under cross-examination, I think that sounds like a fairly convincing case. I think the jurors will be asking themselves, what are the chances that the man whose DNA was found on the knife sheath happens to have purchased a knife, happens to have had a consistent vehicle, happens to have their cell phone location that's consistent with being able to have committed this, happens to have a consistent description, everything else, and a bunch of other stuff that we might not even know about. So that's the way I feel about this case, Tiffany. But like we've all said, let's try to remain as objective as we can and see how this all actually plays out at trial. But excellent question. Let's move along here.
Hi, Josh. This is Natasha from North Carolina, and I have two questions for you. My first question is, with us living in kind of a post-truth society these days, and so many cases being tried in the public instead of just in the courtroom, what do you think the danger is to that? Because to me, I get really worried and scared about people not knowing the full truth. Maybe they just know part of the truth, they don't dig deeper, and then they really stick behind their beliefs. And then my second question is, how do you think the judicial system will stand the test of time in the future? Because I'm thinking about the Supreme Court right now, and we kind of already know how they're going to vote on a lot of things. They're very biased as far as their whatever side they're on politically. And also, it seems like the current administration is overriding or not listening to them, some of the federal judges and things. So just
Oh, we got a part two here.
Hi, Josh. This is Natasha from North Carolina again. My question got cut off, but I was pretty much done asking it. So I just wanted to tell you thank you. And thanks to your team, your wife, and everyone that helps you. And keep up the good work. Thank you.
Thank you so much, Natasha from North Carolina. What a profound question. I appreciate it, and I appreciate the kind words and for thanking my wife, because I thank her every single day. So thank you for reminding me to do that again. So Natasha asked the question. First of all, she makes the comment about what we've been talking about people being tried in the public versus people being tried in the courtroom, and again, there's a huge difference between everything that we learn about outside of the courtroom, the kind of opinions and gossip rumor and conspiracies that we all come up with before the trial, and then there's a very big difference on what is actually presented at trial, and it probably would serve us all well and our mental health and restful sleep to just wait to see what actually is presented at trial in these cases that we care about so much. But then she talks about the kind of bigger question about the judicial or the Supreme Court and our judicial system and everything else. And she brings up about how this current court, I think everybody can agree this current court is, and I'm not getting political at all. I don't want to be political on this channel at all. But I think this current court is leans conservative. I think we can all agree with that. And I know that some people are thrilled about that. Other people are not so thrilled about it. But I got to tell you, this court, if you have gone to law school or you are a student of the Supreme Court, you will understand that the Supreme Court goes through ebbs and flows, and you cannot look at things from the micro perspective of how are we doing this year, or even how are we doing this last 5 years. But I'm talking about in chunks of 30, 40 years time, it goes in ebbs and flows, and the law, it moves like a glacier. And so the effects of decisions being made now may be undone in 10 years. And it all seems to kind of float back and forth. And so we arrive at this middle that I think is usually a good way to be and a good place for us to be as a country. Here's an example of that. You could argue this is one of the more conservative courts that we've seen in a long time, and I would probably agree with you. But it wasn't so long ago that we had one of the most liberal courts that we've seen in a very long time. When you go to law school, you learn about the Warren Court. This was Justice Earl Warren. There he is. He ran the court from 1953 to 1969. Okay, so we're talking a matter of 16 years. 16 years was seen as being one of the most liberal courts that we've ever had in this country. And they had a profound effect on the current landscape of our criminal justice system, even to today. It was considered the constitutional revolution of its time. What cases am I talking about? Well, there's a little case called Miranda versus Arizona. That case gave us what we refer to as our Miranda rights. There was a case called Brady versus Maryland. All of these cases heard in the Earl Warren Court, the Warren Court years. Brady versus Maryland, where we talk about Brady violations and what the prosecution has to turn over. Gideon versus Wainwright. If you're really getting into the weeds, the Gideon case means something to you because it talks about how counsel must be provided to a defendant even when they can't afford it. There was a time where you were allowed to have an attorney, absolutely, but if you can't afford one, well, sorry, that's just how it works. Attorneys don't work for free. It wasn't until the Gideon case that we decided that's actually part of what the Constitution meant by being able to have an attorney, is that we'll provide you one if you can't afford one. And then Terry v. Ohio. This is a very famous case where you hear about law enforcement all the time talk about a Terry stop. Where are they getting the idea of a Terry stop? That comes from the police do not need to have rise to the level of probable cause, but can have something as low as reasonable suspicion to stop and frisk someone. So all of these things came out of a very, very liberal court. And I will tell you that they all started out on one side of the political spectrum. And then over the years, it's been kind of course corrected that some of these rulings have been kind of tailored down. And like I said, end of the day, it all kind of ends up in the middle. But great question, Natasha. And thank you for giving us an opportunity talk about all of that. All right, let's move on. I'm telling you guys, I hope you brought your notebooks. This one is a learning episode of Sunday Fun Day. All right.
If you could interview one person, living or dead, about the law, who would it be?
That question comes from Patty. I thought long and hard about this one, and the answer I keep on arriving at, though I've tried to think about other people, and the person I would love to interview about the law is my dad. My dad passed away a few years ago. He was a lawyer. I grew up in a house where we had our dad was a lawyer. Then my brother became a lawyer. I became a lawyer. I think I went to law school kicking and screaming and trying to find every other vocation I could have gone into other than being a lawyer, but I'm very glad that I did become a lawyer. My dad was able to see me pass the bar. He was able to see me start my time as a prosecutor at the DA's office, but then he died shortly thereafter. And it's funny because we never sat down and really talked about why he became a lawyer or practicing law or any of those other kind of bigger questions that I think, Patty, you're really asking about. Yeah, there's a lot of things I wish I could have shared with him, including that he's got 3 beautiful granddaughters that he never got a chance to meet. But great question, Patty. I'll probably be thinking about that one for a while. But he was a brilliant man, also a little difficult to deal with. He was a boxer and he was a Marine. So you can put all those things together and you can imagine a little bit what it was like growing up in the Ritter household. Anyhow, thank you very much, Patty. I appreciate you asking the question. All right, let's move along here.
Hey, Josh and everyone at Courtroom Confidential. This is Amanda, also known as Super Planner Girl. I come from you by way of STS, and I really enjoy your content. I had a question regarding the Bryan Kohberger case. I wanted to know what your thoughts were on the defense motion to limit certain words like bushy eyebrows, and I know there are others as well. Thank you. I hope y'all are well.
Thank you so much, Amanda, and shout out to Surviving the Survivor, big supporters of this channel. We're big supporters of them. Joel is doing fantastic work over there, and I appreciate any opportunity to collaborate with him, and I hope we will do much more of that in the future. But Amanda asked a great question because the defense did come out with, first of all, the defense in this case has been very thorough and very aggressive. And I always applaud that. Listen, do your job. They feel that they are on a campaign to save their client's life. I think that they feel if Idaho pursues the death penalty, which it looks like they likely will be doing in this case, that is their job to save their client's life. Okay. With that kind of mission, they've left no stone unturned and have been incredibly aggressive. Now, some of these things I think are a little much, and some of them I think are a little petty, and some of them I think are probably a waste of time, but they're going for it. And they recently filed a motion to limit certain words. One of the words they talked about was bushy eyebrows. Well, the prosecution, I think, very cleverly found a way to say that bushy eyebrows, in fact, are important in this case. And if you actually question whether or not the eyewitness, was too intoxicated to describe bushy eyebrows, let's go ahead and let the jurors decide for themselves. Well, how can we do that? Well, let's find a photograph that's close in time to when these murders took place of the defendant. Oh, lo and behold, we have a photograph that we recovered from his phone that he took the morning of the murders, after the murders, within hours of the murders, that he took himself. And we'll go ahead and show that photo to the jurors to see and let them decide for themselves whether or not he has bushy eyebrows. Ladies and gentlemen, this photo is not about bushy eyebrows. This is about, if you believe this is a man that just stabbed to death 4 college students with a K-bar knife after sneaking into their home in the middle of the night, this is probably one of the most chilling photographs you're ever going to lay your eyes on, because I see a person with a haunting grin, giving a thumbs up. Just everything about it gives me chills. The way he's got his shirt buttoned up to the top button. He looks to be standing in a bathroom. He's wearing ear pods. I mean, I've looked at this photo probably longer than I should, and everything about it is haunting and disturbing. And they found an opportunity to make it relevant because the defense made bushy eyebrows relevant. And now they're saying, great, let's take a look at his eyebrows here. Stacey Broadway says, isn't the bushy eyebrows just eyewitness testimony every day and twice on Sunday? Yeah. I know they're trying to keep her out because I think as limited as her eyewitness identification, if you want to call that, of Bryan Kohberger is, I think it's still, like I said, damaging because it's consistent, because she didn't say, I saw a 5'2" overweight gentleman who was bald inside the house. She described the person who was generally of the same height, build as Bryan Kohberger, and the one thing she said that stood out to her was bushy eyebrows, and lo and behold, this man, I think, in that photo, has bushy eyebrows. But they're also trying to keep out things like referencing Bryan Kohberger with the word murder or psychopath or sociopath. And I think what they're trying to do here is saying, we don't want witnesses just labeling him. I think that's not a horrible argument if what they mean by that is not labeling him without some sort of foundation for it. In other words, if you have a lay witness go up there and talk about this psychopath did this, or this murderer did that, or this sociopath, that's just kind of name calling, and keeping that out might be important. But if it's an expert who's going to be giving expert testimony on the psychological state of mind of Bryan Kohberger after having examined him and describes him as a sociopath, I don't see how they could keep that out. I will tell you, this is kind of in the bag of tricks of defense attorneys. I had a case, oh man, this case still gives me nightmares, where I had a very aggressive and litigious defense attorney, and then I had the perfect storm of the judge just seemed to give him everything he asked for, and it drove me nuts. And one of the things that I nearly lost my brain over is he wanted to prevent me from referring to my victim in the case as a victim. He wanted me to use the words complaining witness. And I nearly threw the table over when the judge was actually considering this whole thing. And it came down to, listen, I had to actually show that the criminal complaint against him described the person as a victim, and I'm just using the language of the complaint. And so it was just mind-boggling to me that the judge would even allow for that. And it came down to, listen, this isn't about rhetoric. If I want to use certain language, they can't prevent me from using that language. The jurors are instructed that my questions are not evidence. The evidence is the evidence, on and on and on and on and on. You can tell I'm still smarting from the whole thing, but goes back to this kind of greater point that Amanda asks about language, even down to words used, is sometimes something you're going to be seeing heavily litigated, and especially a case like Bryan Kohberger. I think this case is just going to, I don't think we're done with it, by the way. They're just going to make sure that they consider every possible avenue that they can to try to defend their client in this case. And I think they've got their work cut out for them, because I think the prosecution is shaping up to be a very difficult prosecution for them, or a very difficult defense for them. I'm just laughing at Kaylin. She's giving me looks like, don't touch her presentation. Kaylin, I'm moving on. Catch up. All right. let's get to our next question here.
Hey, Courtroom Confidential and crew. It's Sonia in Chicago. So, do you remember? Well, you're not the only one, because now we have Lori Vallow, who's going pro per or pro se. So, anyway, what I'm getting at is I remember you and other creators just saying, representing yourself never goes well. It's never a winning proposition. Never goes well. Well, so I was like, I wonder if there's anyone who ever did win. So, I sent you, I sent it to the gorgeous Tiffany, an example of somebody who actually won. And it's very interesting. And can you talk about it? And there's others, a handful, maybe an idea for a show. I don't know. All right. Thank you. Bye.
Great question, Sonia from Chicago. You make an excellent point. The saying goes that the man who represents himself in court has a fool for a client. And I still stand by that. I think that anybody who decides to go ahead and represent themselves when their life is on the line is really asking for trouble. But are there instances where that proves to be, are there exceptions to that rule? As with any rule, absolutely. And she brings up this case that I had never really even heard of, so we looked it up. The gentleman you're looking at here is Giacomo Jackie DiNorscio. I know I'm butchering that, so somebody's going to have to help me out. Giacomo, maybe it's Giacomo Jackie DiNorscio. He was part of the Lucchese crime family. And he was brought up in an indictment with 20 other defendants in the case of U.S. versus Anthony Achaturo. And interesting thing about this case, amongst other things, is that it was, I believe, still the longest federal trial of all time. It went on for 21 months of trial with 20 different defendants. But at the end of the entire case, it only took jurors 14 hours to deliberate and find everybody not guilty. How in the world could the prosecution have blown a case like this? Well, a lot of people place that at the feet of Jackie DiNorscio. And they say that what happened is that midway through his trial, he fired his attorney and decided to represent himself. And apparently the jury just found him to be incredibly charming. And he was affable and funny and self-depreciating and would make kind of offhanded comments. And he had the jurors laughing and liking him. And many people credit him with being able to persuade these jurors to the point that they made a movie about it. There was a movie directed by Sidney Lumet called Find Me Guilty, starring Vin Diesel of all people. And I have not seen it, but apparently it retells this entire story. I'm going to look into it. I'm going to watch the movie. And I do think that might make an interesting topic for a show of all the people who have represented themselves that have come out to be victorious. I've never seen it. Every time I've ever seen it, they go down in absolute flames. But I love that Sonia brought up this case, that we were now able to look it up. So we will. I'm going to do a little research by watching this movie, Find Me Guilty. And thank you again, Sonia, for asking the question. Katrina Bunny says, "Are you allowed to fire a lawyer in the middle of a trial?" Sure. Problem is, that doesn't mean that you start over. That doesn't mean that you get a mistrial. It means likely what happened here to Jackie is that fine, but you're representing yourself. And they, I imagine, took all the proper waivers and everything else and allowed him to represent himself. I mean, as much as you have a right to have counsel, you also have a right to not have counsel. And you certainly don't have to be represented by someone that you don't like and don't agree with. But that doesn't mean that you get to derail the thing for everybody else. Full-throated motion says, so you don't need to know the law. You just need to convince 12 random strangers to like you. Yes, I've built an entire career of that. knowing very little about the law, but hoping that I can get people to like me. So yes, I think charm goes a long way. As you guys, I'm sure know, watching some of these trials, it's the more charming attorneys that might be doing better in court than the others. Great question, Sonia. Thank you so much. All right, let's move along here to our next question.
Hello, Courtroom Confidential crew. It's Alicia K. Mayo from Tennessee. Okay, Josh, you asked about show ideas, so here's mine. Joshua, you will present both the prosecution and defense sides and strategies. Get a detective and a forensics expert to speak to those 2 points of the investigation, because you don't want too many people in the mix, but you want the right amount of people participating. And twist, possibly consider awarding the hosting job to a CC crew member so they can do things like introduce the show and any segments or transitions in the show. And don't forget to do periodic updates when and if they occur. Thanks, y'all. Have a great Sunday. Bye.
I love that, Alicia K. Mayo from Tennessee. I think that's a fabulous idea. And you suggest that we should have a crew member for the host. I nominate Alicia K. Mayo to host this show. What do you guys all think? We had asked you guys during the members live, I think, to give us ideas. I was asking kind of what television shows do you watch that are along the lines of like a Dateline or a 48 Hours or a 2020? Is there any other shows out there that you guys are enjoying that we should check out that could maybe give us some ideas? But Alicia K. Mayo went and ran with it, and I think she came up with a fabulous idea. So Alicia K. Mayo, just send me your headshot and resume, and I think we'll put together an audition tape for you, and I think we'll get rolling on this whole thing. She says, "Not me. I sounded like cornbread and turnip greens." I love it. All right, that I'm gonna have to use that in my. I'm gonna have to use that. Thank you. Always great to hear from you. All right, let's move along here.
I was wondering about the Sidney Powell trial. It's about a girl who was in college and she stopped going to college. Well, actually, she was suspended and she was 20 years old, I believe, and she didn't want to tell her parents. And things kept closing in. And finally, her mother was actually on the phone with the college and they were about to tell her that her daughter was suspended. And Sydney picked up a metal frying pan and hit her mother in the head. And the college dean, I believe, could hear everything that was going on. And then the daughter started stabbing her mother, I think like 30 times. And she was found guilty and got something like 15 to life. But it was overturned because they felt like she hadn't got to be presented. And I was just wondering what's ever happened with that trial. Are they going to retry her or what? I can't seem to find anything online about it. Thank you. I appreciate it.
It was a brutal case. Mish Woodside says, thank you so much for that question, Karen. And you recall the facts of this case very, very well. And I will tell you the latest that I know about it, but I searched around and I don't have a status as to whether or not the prosecution is actually going to retry her again, though I suspect that they will. But you're right. She was convicted of murdering her mother. She did hit her with a cast iron skillet. But beyond that, she then stabbed her 30 times and she was sentenced to 15 to life. But that was all overturned. There's a very interesting reason for why the appellate court did that. The judge, this is a quote from the court. It says, the trial court denied Miss Powell's motion. she had a motion to bring another expert in. This all came down to a lot of expert testimony. The trial court denied Ms. Powell's motion based solely on the conclusion that there has been, quote, lots and lots and lots of expert testimony in this matter. They go on to say that under these circumstances, however, Ms. Powell had an unconditional right to present rebuttal testimony. The defense did call 3 experts, and the judge basically said, here's what happened. The defense called 3 experts to put her mental state at issue. It was essentially kind of an insanity defense. The prosecution then called a expert in their rebuttal case. So it goes prosecution case in chief, defense case, and then prosecution rebuttal case. But what the court reasoned here is because in their defense case, because they put on the affirmative defense of insanity, it essentially became the defense's case in chief. And therefore, the prosecution rebuttal to that should have allowed for a defense rebuttal to the prosecution rebuttal, if you follow me. In other words, because they had presented a case, the prosecution rebuttal should allow for a rebuttal to the prosecution's rebuttal because the defense had put on an affirmative defense. If you can follow all the ping-ponging I'm doing here. Essentially, they said, even though you don't have an absolute right to a rebuttal when you're offering an affirmative defense such as insanity, you basically are, because you're shifting the burden. The burden does shift. There is a burden on the defense with an affirmative defense, and therefore their rebuttal is considered a case in chief, and they should be allowed a rebuttal. I hope that all makes sense. If you need me to draw a diagram of the whole thing, Kaylin's really good at drawing stuff. But that's basically what happened on this case. And they said she needs a new trial. And last I heard, the prosecution said they're absolutely going to do that, but I have not heard the status of the whole thing. I will tell you this, though. You hit your mother with a frying pan and you stab her 30 times, they're likely not going to let it go. And they're likely going to be re-prosecuting this case. And when they do, we will be following it closely. So please stay tuned, Karen, and we will continue to try to provide you updates where we can. All right, let's move along, though. Great question.
Hey, Josh. Jacqueline Ellison here from Calgary, Alberta, Canada. My question for you is regarding the Bryan Kohberger case and the eyewitness testimony, specifically about the bushy eyebrows. I just wonder if the defense can use the fact that the girls were out partying, or the girl that spotted, I can't remember which roommate it was, just maybe around that credibility, because I know that a lot of people have had questions around why they didn't call law enforcement sooner, but just wondering, even if that is put into the prosecution's case, how credible it is, knowing the fact that they were most likely partying and under the influence. How credible could they really be? I'm just wondering if in the scheme of things that will be strong on the prosecution side when it's really hard to say based on the fact that they were under the influence. Thank you so much.
Jacqueline from Calgary, Alberta, Canada. Excellent question. Thank you so much for asking that. And to answer your question, will the defense attack the credibility of the surviving roommates' testimony because they were drunk? 1,000% yes. 1,000% yes, they will attract their credibility. But the bigger question is, will that affect the jury or not? And I think end of the day, this entire case does not rise and fall upon those surviving roommates. Is it going to call into question their descriptions of what took place that evening? They also talk about hearing certain things at different times, hearing what they thought. I think they said something about they heard a person said it's going to be okay, or I can help you, or something like that. They talk about kind of a whimpering sound, all of these different things. End of the day, though, this case does not rise and fall upon the testimony of the surviving roommates. The surviving roommates, I think, are helpful for setting a timeline. I think that we have their text messages, which are not influenced by alcohol, to give us part of that timeline. And I think as far as that description goes, again, it's not so much that that description is a description that positively IDs Bryan Kohberger. In other words, I don't think we're ever going to have a moment where that roommate is on the stand and the prosecution says, "Do you see that person in court now?" And she goes, "Yes, it's that man sitting right over there." I doubt that's going to happen. Could be that she sees him and goes, "Oh my God, I recognize him." But we haven't heard anything like that, and I doubt that we will hear anything like that. But what she can say is, "I saw a guy. The guy appeared to be X height." Well, what is Bryan Kohberger's height? Okay, yeah, consistent. He appeared to be, X build. That seems to be consistent. He had bushy eyebrows. Will you go ahead and decide for yourself, jurors? Are those eyebrows bushy or not bushy? And were you drunk? Yeah. Do you remember everything? Not great. Do you remember the time? No, not so much. Were you a little confused? Yes, I was. Okay, so what? It goes to, in other words, this is something we talk about in the law all the time. It goes to the weight, not the admissibility. In other words, it's something the jurors are going to hear. It's admissible evidence, and they can decide for themselves how much weight to apply to that, how much credibility to give to all of that. But again, none of what that roommate says is going to change the fact that his DNA was found on the knife sheath. Did I miss a question there, Kaylin, in my pontificating? Oh, Southern Cali B says college students party. I think jurors will take that in. Yeah. And I also don't. Yeah. They're living in a house where people are coming and going. They're living in a party house. They're having drinks. They're all behaving differently than any one of us would have behaved. Try to throw yourselves back into your early 20s back in college, and maybe we can understand. But excellent question, Jacqueline from Alberta, Canada. Thank you so much for asking. Let's move it along here.
Hi, Josh. This is Susie from California. What I'm wondering is, in the Karen Reed case, now that Trooper Proctor has been fired for his conduct in her investigation and he's presumably going to testify, that seems like it's going to be really bad for the prosecution. At what point does the prosecution look at what they have and decide to drop the case? Does that ever happen? Looking forward to your answer, and thank you for your fascinating shows. Bye.
Thank you so much, Susie from California. Yes, on the Karen Reed case, the lead investigator, Michael Proctor, was finally fired by the state, Massachusetts State Police. And what effect will that have on the prosecution? Well, it's not great. It's not good. There's been a lot of people who talk about, is the prosecution even going to call him? I think they are going to call him. Because I think if they don't call him, the defense will call him. And that will be much worse if the defense is the one who is calling him and presenting everything he did. And I think the defense absolutely has a reason to call him. He's the lead investigator. So it's not so much that they're going to call him merely to throw him up there to dump on him. It's that he's the lead investigator. It's important to hear from the lead investigator, and it will look bad for the Commonwealth if it's the defense calling him, asking him questions, and then leading him through all of the awful text messages that he left. I think the Commonwealth, if they're smart, and if I were handling the case, I would call him. And I would ask him about the text messages. And I would walk him through every single one of them. And I would talk to him about how awful they are and how bad a person he is and how ugly they are and how he should never do this. And in fact, sir, weren't you fired over this? And steal as much of the thunder away from the defense as I possibly could. And then try to make an argument of, listen, the state police dealt with this man. The state police dealt with this cancer amongst their ranks. And try to make the argument that you don't throw the baby out with the bathwater, and that these are not mutually exclusive things. That Trooper Proctor can be a horrible, horrible man. I'm not calling him a horrible man, but he could be a bad investigator and have said some horrible, horrible things. And that doesn't change the fact that they collected the evidence that they did. Now, is that kind of a weak argument? And as you hear it coming out of my mouth, you can see how it's kind of putting the prosecution in a defensive posture. but it is what it is. I think they're just going to have to deal with it and get out in front of it as much as they possibly can. But then to Susie's other question, would they ever decide to drop the case over Proctor? I think that's the way they think about it, though, is that, listen, we're not going to allow one bad apple to ruin this case for us. We're not going to allow the things that he said on text message to eliminate the other evidence and what we believe is the right thing to do here. And again, whatever that is, however you guys come out on this case, and I know this is probably the most third rail case that we have going on right now, but I think the prosecution's belief is that a man was killed and something should be done about that, and that they have the evidence to link that to Karen Reed. And the way that they got there may be ugly and messy and full of mistakes and everything else, but that doesn't necessarily mean that you drop the entire case. And believe me, as a prosecutor, I've had cases where the cops have done very stupid things and they've made mistakes, and it's in not every case is neatly packaged, but you got a job to do. And I think that's the way that they're viewing this. So I hope I didn't light the entire chat on fire with all of that, but excellent question from Susie from California. And I appreciate you bringing that up for us. All right, let's move it along here.
Hi, Josh. This is Pam from Michigan. I have a couple questions about the Lori Vallow Daybell trial that is coming up. I've been watching or listening to a bunch of podcasts, Dateline interviews with Keith Morrison, etc. So my questions are, if Lori gets argumentative, gets sassy, pushes back, which we've seen her do a couple times in court, what does that do to the trial? Is this going to cause delays? Are her defense attorneys that are just sitting on the sidelines advising her, are they ready to take over and pick up where she left off? Or do they have to back up? Or do they have to start over in a year? Like, what exactly happens if Lori just can't control herself? And where is the line that the judge draws in the sand and says you can't go any further as your own counsel? So just wanted to ask that question since the Lori Daybell trial is coming up. Thanks so much. Love your podcast. Love listening to all your interviews. They are awesome. Keep up the great work. Thanks so much.
Thank you so much, Pam from Michigan. Great question. Marta Fonda says, good question, caller. I agree. Great question. I think we actually talked about this a little bit on the last Wednesday Night Live, but listen, is there any controlling Lori Vallow? I think absolutely not. Is she going to do what she's going to do? Yes. Is there, this is not a person who plays by anyone's rules but her own. And I think, yes, there are going to be moments that absolutely cause trouble in this case. What does the judge do about that? The judge is going to admonish her. The judge is going to excuse the jurors and take a moment and admonish her. And we're probably going to have a lot of weird sidebars, and we're probably going to have a lot of, out of the presence of the jury conversations. And it's probably going to be long and difficult and fascinating to watch. But what if it goes too far is the question. What happens then? Well, a judge can decide that you are being so obstructive to the process and you are begging for a mistrial here that I'm not going to allow it to happen. And a judge can, and that's what standby counsel is there for, appoint standby counsel. Now, you're still going to have the problem of Lori Vallow in the case, and she may still try to cause trouble. And so we're just going to have to slog through it to secure a conviction, because otherwise, what do we do? We can't just let it end because the defendant doesn't want to participate. And listen, there are cases, that you don't hear about where they have incredibly difficult defendants. I've had cases where a defendant has been brought in, not me personally handling it, but cases I've been a part of where a defendant's been brought in like Hannibal Lecter style. I'm talking wheeled in, handcuffed to a wheelchair, spit mask over their face, sitting there screaming through the proceedings, and we all had to get through trial just to handle it because we're not going to allow a person to obstruct justice. I don't think we're going to get that far with Lori Vallow, but I'm saying judges have dealt with more difficult things. And that's why you have standby counsel. So she decides to cause too much trouble, or she decides she doesn't want to represent herself anymore. Standby counsel steps in. They're ready to go. We don't miss a hitch, and we continue on with the trial. Terry L says, do you think she should have asked for the continuation? It doesn't seem like a great idea to go forth without her experts completing the work. I agree. If I were dealing with a normal human being, I would say ask for the continuance so your experts can be ready. But the judge did a remarkable job of admonishing her of all the consequences of not. And she said, I want my trial anyway. So she's going to scream about it. She's going to say my experts aren't ready. I wasn't given enough time. And the judge is going to tell her and probably read back to her her own words of how she decided not to get that continuance. Will that be an issue on appeal? Yes. Will it be an issue that wins? Likely no, because this judge, I think, is doing a remarkable job. Thank you, thank you, thank you, Pam from Michigan. Let's move it along here.
Hey Josh, this is Kathy. I finally got up the nerve to call. Congratulations on 25K. I really don't have a question because you answer them as soon as I can think of them. But awesome job. Hi everybody. I did it. I'll do it again. Thanks. Love your channel. Bye.
Oh, Kathy, thank you so much. I'm going to hold you to that. Thank you for the congratulations on the milestone of 25,000 subscribers. Appreciate you, and I appreciate you working up the courage to leave us a message, and I hope that you leave us another one soon. Thank you.
Hello, Josh. What is happening? This is JC Broadway. Happy Sunday Fun Day to all. Last time I called, I asked if a prosecutor had the power to refuse a case, and you said that they can say that this case is hot garbage. So I'm kind of wondering what the prosecutors in the Nichole Rice trial were doing, and why didn't they say that case was hot garbage, at least in my opinion. She might have done it, but whoever did it is still out there. It was just terrible. So I wondered your opinion on that. Also, I think we should have an emoji for hot garbage, but I guess we do have trash burning dumpster fire. I guess that would work for both. Anyway, one of my favorite Joshisms of yours. I thought I would do something. I'm going to run out of time. I'm going to try to be fast. So I Googled bar exam practice questions. I thought we could have a little pop quiz. I know there's a couple people in the chat either studying for the bar exam or have a loved one who is. So first criminal law question that came up is regarding grasping the concept of intent. I will read you the question. It's probably the most difficult question on the bar exam. Question, can Anne be convicted of burglary if her defense is that she entered the building solely to seek refuge from a sudden storm? 1, yes, Anne can be convicted of burglary even if she entered the building to seek refuge from a sudden storm. 2, no, Anne cannot be convicted of burglary if she entered the building solely to seek refuge from a sudden storm. 3, maybe. It depends on whether Anne had a history of committing crimes. 4, it depends on the severity of the storm that Anne encountered. I mean, do they give you a throwaway option? I'll give you a hint. It's not 4. Happy to answer in the chat if anybody wants to know. All right, thanks. Bye. Call me back.
JC Broadway, I love this. I love this. First of all, thank you, longtime supporter. Appreciate hearing from you. First of all, to your more important question, when you light a dumpster on fire, you get hot garbage, right? I mean, it's the same thing. A dumpster fire creates hot garbage. Was the Nichole Rice case hot garbage? I think the Nichole Rice case was an incredibly difficult case that did not get better by waiting 15 years to bring it. And I think that I am still astounded by why it took them so long. And I think that the it's unfortunate that now the family of the victim is left with a position where the case they probably could have had was probably lost several years ago, and now they'll never get an opportunity in court to have somebody held responsible for that. So, putting that aside, let's get to this burglary question. I love this question. And the question is someone who breaks into a home to find shelter from the storm guilty of burglary? Now, my first, and I hope I get this right, is JC in the chat to give us the right answer, but let me give you my guess. Burglary, this is interesting. One of the first things you learn in criminal law in law school is what the common law definition of burglary is. And burglary is the breaking of entering into a home, by the way, at night with the intent to commit a felony therein. That was the old school definition. Oh, you're here. Good. The old school definition of burglary. So it's got elements, right? You have to break in. So what does that mean? Breaking and entering into a home. Well, what is a home? You have to break that down. At night, well, what is that considered at night? With the intent to commit a felony therein. Now, we have since discarded the at night point, but all of the other elements kind of remain today in the definition of burglary. It's breaking and entering. So still have to find out after years of common law, what is breaking and entering? What is a home? Does a home include a garage? Does a home include a boat that you live on? And what does it mean to commit with the intent to commit a felony therein? And I think that's really what they're talking about here is finding shelter from the storm an intent to commit a felony therein? Is snooping through somebody's sock drawer a felony that you're intending to commit a felony therein? All of these become very interesting questions. And that's why I think that it really has to, I think it was number C, has to do with the criminal history of the person involved, because if they had committed a bunch of other burglaries, that might speak towards what they were actually intending to do, and whether that was to shelter from the storm or to steal their jewelry. But I'm curious to see if I would have passed this question, whether JC, if you have the answer for us, please let us know. But that's great. That's exactly what you do in law school, is you just sit there and go break down all of the elements and try to figure out. I mean, that's how the law works, is it gives you the law, and then you have decades of common law history to go through to try to figure out what each and every one of those terms is. Shy Gal says she guessed number 3 as well. No, Anne cannot be convicted of burglary if she entered the home solely to seek refuge from a sudden storm. So there's your answer. I would not have passed the bar if I had to take it today, but that's what it comes down to, is that seeking refuge from a storm is not an intent to commit a felony. So breaking and entering would not qualify as burglary in that, or would not qualify as burglary, the breaking and entering at that point. Great question, JC. Appreciate it. All right, let's move along here.
Hello, community. Happy Sunday morning. This is CJ in LA from Los Angeles, and I hope you're all doing well. Hearty congratulations on 25,000 followers. This is very exciting, and I'm so thrilled to be a part of this community. So I remember that morning of October 3rd, 1995, very vividly. I was a young teen, and it was the second period of high school. The very diminutive tech aide wheeled in that mammoth Panasonic television and tuned into some local network because the adult world had caught wind that the O.J. Simpson verdict was in. And it's incredible to think that school children around the country were watching in school the verdict of a man who was accused of brutally murdering his wife and her paramour. And as an impressionable BIPOC teen of the time growing up in Los Angeles, I was acutely aware of the social unrest that preceded our city in the early 90s. We saw the Rodney King brutality, the officers get off, and the subsequent social unrest that underscored just how divided our city and our country really was when it came to race, justice, policing, and accountability. For many of us, especially in communities of color, it felt like the scales of justice had tipped just for a moment, even in some skewed and dysmorphed way. It was an emotional and deeply complex time for many of my fellow BIPOC friends and their families who've endured generations of absolute indignity. Now, 30 years later, I reflect on that day and the necessary conversations it sparked about race and equality. I'd love to hear your thoughts and reflections, either from that moment in time or as a trial attorney now. Thanks so much, and I appreciate all you do.
Thank you so much, CJ, for that excellent question. Yeah, I mean, I think everybody it's one of those things where everybody kind of remembers where they were when they found out about the either OJ getting arrested or the OJ verdict. I as well was in, chef's kiss to that question. I as well was in law school at the time. Pardon me, high school at the time. And it's so funny. I think I was more, caught up in high school and sports and everything else to kind of appreciate the profound nature of the verdict at the time. I remember this very vividly. I remember when OJ was a suspect, feeling like there's no possible way. It's OJ. What are they talking about? And then when OJ went on that car chase in the white Bronco, I vividly remember being at my friend's house going like, oh boy, oh OJ, what'd you do? And then as the trial played out, I, generally kind of have memories of people barely being convinced that he was involved in the whole thing. And did the gloves fit was a major point and everything else. The verdict, I think, has taken on different meaning to me since my time. And I will tell you that verdict and that case still echoes in the halls of the DA's office. That case profoundly affected the Los Angeles District Attorney's Office. They view that as a colossal failure on their part. And I watched one of the prosecutors on that case was a gentleman by the name of Bill Hodgman. Now, he was not in court. He was originally going to co-prosecute it with Marcia Clark, and he had to step aside because he had actually, I think he had a heart attack towards the beginning of the case, or some sort of heart condition that required him to step aside. And that's when Chris Darden stepped in. But Bill Hodgman was still in the office when I was in the office. Wonderful man. Excellent. One of the nicest people. When I left the office, he was a director. He pulled me into his office, told me how much he wished me luck, told me how much he wished I would stay in the office. Just a phenomenal man. But he gave we would have these things called Saturday seminars, and he gave a presentation one time where he broke down the entire OJ case and all the evidence that they had. And you forget about just how much evidence they had in that case. And it was tremendous. And I think what it showed and what it taught that entire office for years and years and generations to come was, no matter how strong your case is, don't take it for granted. And I think they took for granted the effects that the defense would have on that case, from the effect of showing police the perception of police corruption and racism and clever things like the glove doesn't fit and everything else. And they convinced that jury to see the case otherwise. And I've watched nearly every documentary and everything that's ever come out about it ever since then. And I still think it's just, to answer your question, what was my reaction? My reaction at the time was probably less blown away than it has become since then. And I still think it's one of those cases that we will analyze for years and years to come. Pro Hoc Ceviche, what a name. What a name. Fantastic. Says, yes, I was in high school too, for all things OJ. They brought a TV into class to watch the verdict. It was a cultural moment. It's amazing how much it was a cultural moment and something that we were all just talking about for years and years to come. Did you see Court TV's OJ commercial with Josh in it? Thank you, Wifey for pointing that out. Yeah, the Court TV is doing some big special on it, and they asked us to kind of give our reactions, and they included us in a few of us in a commercial for it. So check it out. All right, good stuff. Let's keep it rolling here.
Hey Josh, this is Christina Evans, and I want to win some criminal coffee because I've bought it before and it's delicious. My question for you is about your background. I remember you saying a few months ago that you're planning to change your background, and I was wondering what those plans were, and if you could tell us a little bit about how you're going to change your background. Thank you. Bye.
Great question, Christina. And just to clarify, Christina is not talking about my criminal background. I cannot change that. What she's talking about is our lovely background here with my plant that never seems to need to get watered, and the books that we have on the shelves. And yes, we want to upgrade it. You'll have to talk to my attorney, Tiffany. We want to upgrade the background, and we need your help, though. Give us some ideas. You know what I would love is suggest to us perhaps maybe other channels that have a background that you like. We're having a tough time because we know that we want to kind of give more depth and put more kind of interesting things. But I keep on telling Tiffany, I don't want it to be too YouTube-y. Like, I don't want neon lights or anything like that. I want it to kind of be simple and classic but yet a little more engaging than just my two shelves. We'll have to put our two shelves into storage somewhere and say goodbye to them. But that is one of the updates that we hope to have coming in this coming year. So love your feedback. Let us know somebody's background that you like. Give us some suggestions. It's up to you. Thank you, Christina, for bringing that up. Recovery addicts. Yeah. He's got a lot going on in he's got the multi-camera view too, that Scott's operating on a different level than I am. Oh, Melissa says she loves the simplicity. Yeah, we're going to keep it simple, but we feel like we need something a little better than what I got going on here. All right. Oh, you can't hear it? Can't hear it? Oh, correct. Criminy. Hold on.
Hi, Josh and crew. Kathy Davidson from Central Washington State. Just finished watching the weekly roundup, and it looks like we're all going to be busy for months to come. I can't wait. I'm calling today with a question regarding grand jury testimony and getting immune for life. I had watched a Dateline show dated March 21st, Caitlin Conley, the murder of Mary Yoder, and they had made a statement in there that some people that testified in front of the grand jury received lifetime immunity, so they can never be tried even if they were involved. That just kind of floored me. So can you speak on that? Also, wanted to mention that I really liked your show when you had Matt Murphy on. I ordered his book. It is excellent. Everybody needs to read it. It's The Book of Murder, and he writes it so well, you will not want to put it down. I had it read in less than 2 days. I could have done it in a day if I could have stayed awake. So just pointing that out. I hope you all have a great week, and I'll see you guys on Sunday Fun Day. All right. Thanks, everyone. Bye.
Thank you so much, Kathy from Washington. Yeah, first of all, Matt Murphy's book, Book of Murder, is excellent. And it's you got to check it out. It's well worth reading. He reads it himself on the audio version. It's also really interesting to listen to. And I tell you, I was telling this to Tiffany the other night. She started reading it, and she turns to me and goes, "Did Matt actually write this?" And I asked him the same thing. And I tried to do it in a way. I'm like, I respect you. You're an amazing attorney. I'm a big fan. But being an attorney and being a writer are entirely different skill sets. Did you actually write this? And he's like, yes, I did. He's a phenomenal writer. It's a really, really good and engaging book. And it's basically about his career. And he talks about all sorts of cases that he's handled. And many of them you may have heard of. Some of them you may not have heard of. The ones that I had not have heard of are actually some of the more fascinating ones. But it's a great book. And he talks about his career and his kind of things he was going on in his personal life and everything else. Really good. Book of Murder by Matt Murphy. Definitely check it out. But Kathy brings up a case that I was not aware of. She brings up the case of Caitlin Connolly. And Caitlin was convicted of murdering her boss, Mary Yoder, Yoder. Do we got Caitlin's picture here that we could put up? Sorry. Now, the there was two documentaries actually done on this that I have not watched yet that I want to watch. And it's called Little Miss Innocent, Passion, Poison, Prison. And you've got to imagine there is an intern somewhere still patting themselves on the back for that title. Little Miss Innocent, Passion, Poison, Prison. And the story goes, and I just looked up the facts and read some articles on this really quickly, but I want to do some more research on it. Mary Yoder was a chiropractor, and she died on July 21st of 2015. Unexpectedly, drops dead, complains of stomach pain, goes to the hospital. Within hours, she's dead. And they do an autopsy, and they realize that she died of colchicine toxicity. I've butchered that name. But basically, it's poisoning from a drug used for the treatment of gout. Well, Mary didn't have gout. So how in the world did something like that happen? Well, then investigators receive an anonymous letter saying that her son, Mary's son, Adam, is responsible for the murder. And in fact, you can find the medication in his vehicle at a certain spot. Lo and behold, police go out, they search his vehicle, and they find the drugs where the letter said that they were going to come from. So now they think, could Adam be involved? Well, they sit down and they interview Adam. At the time of her murder, he's 300 miles away. Later on, and this is some of the stuff that I'm still curious about, they're able to track the letter back to Caitlin Connolly. Caitlin Connolly was a receptionist at Mary Yoder's chiropractic office, and she happened to have been an on again, off again girlfriend to Adam Yoder, the son. And it started to look like Caitlin had done this in some sort of twisted and weird way to either get back at him or get back together with him. Now, after that conviction, she goes away for life. She has her conviction overturned because the Court of Appeals felt that her attorneys had dropped the ball in not challenging a warrant and that warrant was improper. I don't know the final disposition of this whole thing. I'm going to do some more research for you guys, and I'm going to find out, and I'm going to watch those documentaries because I'm fascinated by this case. But Kathy's question is about immunity. And during the grand jury, some witnesses were granted immunity, and it was referred to as immunity for life. So it gives us an excellent opportunity to talk about the different types of immunity. There are basically two types of immunity: use immunity and transactional immunity. Use immunity prevents the prosecution from using the witness's statement, the person who's granted the immunity, their testimony or anything derived from their testimony in a subsequent prosecution against that person. But the prosecution can still bring charges against that person for independently obtained evidence. So think about it this way. We're going to say that anything you tell us will give you immunity on. And if we learn other things from the things that you tell us, we're going to give you immunity on that. But if independent of all of that, we find out a way to connect you to the crime, we can still prosecute you for that, okay? In other words, it's not blanket immunity for this crime altogether, but it's immunity for everything that you tell us. That's called use immunity. The other type of immunity is called transactional immunity. Far less common, far less given, and far more protective of the person testifying. It's considered a blanket or total protection, meaning the witness cannot be prosecuted for any crime related to the subject matter of the testimony, regardless of whether or not that came from their testimony or an independent source. So in other words, you're going to testify about this murder and you will never be implicated in this murder, whether or not that's from something you told us or from an independent way that we have of tying you to this murder. You're forever protected. But that doesn't mean that you're protected for any crime you've ever committed ever. In other words, you're still on the hook for that tax evasion unrelated to the murder, but anything in regards to this murder, you're protected for. So I think to answer your question, Kathy, they were granted transactional immunity, which means that the testimony they give will forever protect them for anything to do with their testimony about the murder or any connection that they had to the murder in any independent way that they have of tying them to that murder. They will never be prosecuted for it. It's a very rare. I never dealt with it. The DA's office when I was there would never grant it. Just never. Just felt like there was never a reason why they should grant it. Or if they did grant it, it had to go up so many different lines of chain of command and so many different memos written that I think it was never worth it to anybody to even try to ask for it. So, but use immunity, far more common, because you're just talking about, I'm not going to use the words out of your own mouth against you. All right. Hope that clears that up. Let's move on. We've only got a couple of more here. So stick with me, guys. And then we are going to announce the giveaway. We're going to announce the big winner, big winner coming up. Stay tuned.
Hey, Josh, it's Christy from South Carolina. I just wanted to say how much I love your channel. I love the community that you all are building. And I don't really have a question per se, but I haven't watched the episode you did with Derek from Big Brother, but I plan on going back to watch it. But my question would be, are you a Big Brother fan? Anyway, thanks for all that you do. And again, I just love this channel and I'm glad to be part of the community. Thanks.
Thank you so much, Christy from South Carolina. Appreciate all your kind words and support. I am not a Big Brother fan. But I do want to watch the season with Derek because I'm a fan of him. And I've heard that his season is the season to watch. And I've heard that the way he plays the game is pretty incredible. I'm just not like a fan of the reality contest shows. I don't have anything against them. I just have never been a fan of them. With the small amount of time that I get to watch television, which is usually when everybody in the house is asleep and I should be asleep, but I just want to watch some TV. I'm usually watching, I don't know, something else, some thriller or something like that. And it's not going to be Big Brother, but I do want to watch Big Brother. What season? I think he told us. I think he said it was season 16. I'm looking at Kaylin and making her Google it real quick. Season 16. Yeah, check it out. And if you haven't checked out the interview that we did with Derek, he's the whole reason we're doing the giveaway today too. His company is the Criminal Coffee Company. But he's just a fascinating dude. And I'm so appreciative that he came on for an interview. And you guys should check out that interview if you haven't already. And if you're able to go to his channel and say that you're saying hello from Courtroom Confidential, I'm sure he would appreciate that too. And I would love him to know how much our community appreciates him. So thank you, Christy, for the question. Let's get on to our last few questions here. Now would be the time for the website to crash, right?
Hello, Joshua, Kaylin, and Tiffany. I hope I remembered your names okay. My name is Kimmy, and I am all the way on the East Coast here in Maine. I am a Grizzly. I started following you a little while back under Gisela K's kind of advice, and I think that it's been really interesting learning about the court proceedings. I don't do any of that sort of thing for work, but I am a survivor, and I like to follow the justice system and see people get justice. That's where my interest is. I have this question about defense lawyers, and please excuse my ignorance, but in cases where it's very obvious where the defendant is guilty, do defending lawyers have to ignore that even if they believe that that person is guilty and they still have to prove them innocent? I'm just curious about that. Thank you so much for all you do, and I hope to hear my question, and take care. Bye.
Thank you so much, Kimmy from Maine. Excellent question. Shout out to all the Grizzlies and to Gisela, and for everybody who's joined our community. We're big fans of Gisela and the Grizzlies, and honestly, she's one of our hugest cheerleaders and supporters, and I'm so grateful to her and everything she does. And Kimmy, you ask a question that I get asked all the time, and in fact, we had many questions like that this week in all the questions we were going through. And it's some variation of the same thing. How do you, as a defense attorney, defend somebody if you know that they're guilty? And Kimmy, I liked her way of putting it because it highlights an important point about all of this. She says, when somebody's guilty, do you still have to prove them innocent? And my answer is no. I only have to show that they're not guilty. And am I being cute? A little bit, but it's actually very true. And it gets to the heart of your question. As a defense attorney, and as our entire criminal justice system, it's not about the prosecution tries to prove them guilty and the defense tries to prove them innocent. It's the prosecution tries to prove them guilty beyond a reasonable doubt, and the defense tries to make sure that that standard is kept. And if they don't reach that standard, they are not declared innocent. No one is ever found innocent in court. And I'm not trying to be, again, cute, and I'm not trying to be a stickler here, but it's very important because a person is found not guilty, meaning they have not met the burden. There may be proof that they did something. There may be evidence that they did something, but if that evidence doesn't rise to the burden of beyond a reasonable doubt, then they are not guilty. But you will never get a verdict of innocent. And it's not on the defense to prove them innocent. In fact, it's not on the defense to prove anything. The defense could sit on their hands through the entire trial. And if the prosecution cannot reach that burden, then they're still not guilty. So how do I do it, though? I will tell you that, first of all, as a private attorney, I get to turn down whatever cases I want. And if I just don't like a person, or if I don't want to defend a person for the crimes that they're accused of, or I just don't like it, I don't have to do it. And that doesn't mean that every person I ever represent is somebody that I believe in their innocence or believe that they're not guilty. It means that when they are even guilty, I believe that they have a reason to be defended in court. And my job is there to protect their rights. And my job, many times, is try to make sure that they just don't get run over and bulldozed by the system, and try to perhaps work out a plea deal for them. And if we do go to trial, to make sure that they, again, don't have the trial is done the proper way, and that burden is kept, and that if there's anything to be proven, it's proven by the people beyond a reasonable doubt. Afton says, have you ever refused to represent someone because of what they're charged with? All the time. All the time. I don't like cases involving kids. I don't like certain types of crimes involving children. There's all the time. I will. I make it. I don't have a blanket rule, but on a case-to-case basis, I will decide. And sometimes I just can already tell that a person's going to be trouble, or that a person's not going to be worth the effort. Yes, and that's a luxury that I have. And thank you for asking, Afton. I am not required to represent anybody. And many times I do turn people down or send them in a different direction and wish them well. But thank you so much, Kimmy, for asking that question. All right. Our final question actually comes to us by way of, and first of all, I want to thank you guys, everybody who left questions. I know that there's a couple that we may have missed, and I know that there were some brand new questions that I saw this morning, but I just didn't have time to research it. We will get to all of your questions. Continue to please ask them. The more that you ask them, the more often we're going to do these shows. But the last question actually comes to us by means of an email. And I'm going to make an exception to our rule here that you have to leave a voice message because Beth, who left the email, was so kind about it. And she actually titled herself Beth Hidden in the Shadows. And she says, this is the email. I don't have the courage to record a message. I have tried. And for that, I appreciate you, Beth. I was wondering your thoughts on the case in Platte County, Missouri, with the Chiefs fan who froze to death after the Super Bowl. Do you think they will be able to prosecute that case? This is a great case, and I appreciate your question, and I appreciate you trying. And Beth, I hope you try again to actually leave us a voice message because I would love to hear from you. But this is the case where the defendants are, first of all, the victims are gentlemen by the name of Ricky Johnson, David Harrington, and Clayton McGinney, pardon me. And as you can see, they're all big Chiefs fans, and they tragically lost their lives on January 7th. It was a playoff game between the Chiefs and the Chargers, and their bodies were not discovered until January 9th, and they had been frozen and died in the snow outside of this home. And the persons who have been charged with this crime are Jordan Willis and a man by the name of Ivory Carson. And what police believe is that Jordan was a friend of theirs and supplied some of the cocaine to these gentlemen, that Mr. Ivory Carson was a drug dealer and had provided some of the drugs which contained fentanyl to these people, and the combined effects of the cocaine and fentanyl left them to the state where they passed out or fell down or whatever, got disoriented, and actually died from hypothermia out in the snow. But it raises a very interesting question, and it's something that I struggle with because though I appreciate and applaud aggressive prosecutions and kind of thinking outside of the box, in this case, they're charging them with involuntary manslaughter for these men's deaths. It's not some sort of negligent providing of narcotics or whatever else. They're holding them responsible for their deaths. And the theory of involuntary manslaughter is that the unintentional killing that occurs during the commission of either an unlawful act, which in this case would be the providing of the drugs, or while performing a lawful act in reckless or gross negligent manner. So they're going with the theory that the providing of illegal drugs was the underlying crime. And if a death occurs during the commission of that crime, they should be held responsible for involuntary manslaughter, which means they're looking at 10 years in prison. Does this satisfy the elements? It might do that. It might satisfy the elements. And that's why street drugs are inherently dangerous. You don't know what you're getting, and you don't know what you're taking. You don't know the dosage. It would be one thing if they gave somebody aspirin, or they gave somebody, a over the counter and they ended up dying, a sleeping pill and they ended up dying, because then you would be arguing about whether or not the providing of that is actually even a crime. But here it's clear cut. It's a crime to provide cocaine and fentanyl. And these people did die. So do they actually satisfy the elements of the crime? Perhaps they do from the very strictest sense. But my bigger question is, do we want to extend the liability to situations like this, where there are intervening factors, perhaps being the cold? Would this been a situation where these men might have just slept it off and just, the next day talked about what an awful night they had? Because I don't think anybody's saying that they forced the drugs on them. They took it willingly, but it just sounds like they tragically, had a circumstance where the cold did not contributed to it, and now they're tragically dead. So I don't know. I don't know where I fall on that whole thing. I think, again, I appreciate the aggressive prosecution. I think the records of both these men might play a role in all of that. If you found out this wasn't the first time where they had problems with drugs, that might play a role in the whole thing. But sad story, crazy story. I remember it made national news because these men were not found for a couple of days, and then they were all found in the backyard in the snow. So very, very sad stuff. But that does bring us to the conclusion of this episode of Sunday Fun Day from Courtroom Confidential. Thank you, everybody, so much for being a part of it. Thank you for all your questions. You're all wonderful. I've had such a wonderful time. Let's get to some announcements really quick and then announce our winner. First of all, yesterday was our weekly roundup. Please tell me you did not miss it. We had we talked about Bryan Kohberger, Karen Reed, Lori Vallow. Please check it out. Oh, and Jeanette. Hey, how are you doing? Good to see you. Then stay tuned for Monday. Is going to be the next episode in our conversation series where we sat down with Greg Hartley. What a fascinating dude. What a incredibly accomplished man he is. He is from the YouTube channel, very popular, The Behavior Panel. Check that out tomorrow, Monday, 5 p.m. Pacific, 8 p.m. Eastern. We are not going to have our lead-up show, the 4:30 show before then. Am I correct on that, Tiffany and Kaylin and everybody else? I think we're just going straight to the premiere of the Greg Hartley interview at 5 p.m. Pacific, 8 p.m. Eastern. That's tomorrow. Please check it out. Then this Wednesday, we have our normal Wednesday night live at 5 p.m. Pacific, 8 p.m. Eastern. We're still working on a guest, I think. Again, I'm looking for Tiffany to help me out. No 4:30 this Monday. And if we have a guest already for Wednesday, please let me know. But I think we're working on it and trying to work on what we're going to talk about. As always, oops, hold on. As always, you can check out our website, thecourtroomconfidential.com, for where you want to find out about membership, where you want to look at our brand new merch that we're coming out with, where you want to leave us a voice message for next time. And I will leave you guys with this little teaser that we are on the cusp of and trying our best to do Sunday Fun Day on a weekly basis, but it really depends on how many of these questions we get. So the more questions you ask, the closer we will get to doing this every week. And I think we're almost there. So please continue to leave us questions. Go to thecourtroomconfidential.com and click on send us a message. Now, big drum roll, please. Are you ready, Kaylin? The winner of this giveaway for a $50 gift card to Criminal Coffee Company was Farm Girl. Yay. Thank you so much, Farm Girl, for entering and for all your support on this channel. You can see from the wheel there, that's how Tiffany does it. She puts everybody's names on a wheel, and then we click the wheel, and randomly we get a winner. We had a lot of people enter, so that was really, really fun. Farm Girl, I hope you like coffee. You got $50 worth of it coming your way from Criminal Coffee Company. What I need you to do, I don't see you if you're still on here. If you're not, when you watch this, and I hope you do, reach out to us. Email Tiffany at media@joshuaritter.com to give us your details on where to send you the gift card. But thank you again. You guys, this has been so much fun. I'm so glad that you all stuck with us. I hope that we got to all the questions that you guys submitted. I hope you all enjoyed it. Thank you all for your support. Thank you for every single milestone that we reach on this channel and as we continue to grow. And that's all because of you guys. Have a wonderful rest of your Sunday. We will see you again next week. But thank you. Take care, everybody. Bye-bye.